chairman of a committee, a select committee. After doing everything, I report to the speaker, who is the arbiter and who is the head of this house. So my outcome at the committee stage, where I chair, where I should pretend as the speaker, is not finality until the speaker says so. So why is the speaker worried? Mr. Speaker, in terms of resources, if we want to save resources, let me say this. Even the people out there do not see us as worthy people to be paid. We can save resources by leaving this house and let the people have more resources. So I am saying my position is clear and our position on this side is clear. Let us save democracy. Let us assure the people of having an electoral commissioner that befits the status of our democratic credentials.
Mr. Chairman, point of order.
Yes.
Mr. Chairman, point of order.
Yes.
I don't think we are here again for another debate.
Of course, I know.
I don't want to open marathon.
I know.
Our position on this other side was very clear, the true sense of patriotism. We make law not because you are sitting on the convenient side or the interest on a normal temperature and pressure on all sides to have a final say for the good of this country. We have made our position. We are going to read that clause in the extant law. We're going to remain the same. And we ask that if there is any definition of consultation, we take it to the Public Elections Act, where will be the general administration of the law. Even this they are proposing, you cannot do the administration of the law in the Constitution. You can take it to the Public Elections Act to define it. I don't want to go over and over what I've said. I have said it without number. What the President did for the appointment of the electoral commissioners, I asked my colleague, times without numbers, that go to the Supreme Court for interpretation. For us, we stand with the extant law. Proceed. We have prepared ourselves to vote for the good of this country. We are standing with the extant provision. I rest my case. No more submission on this side concerning 32.3. No more submission.
Yes, the leader of the opposition.
Yes, Mr. Speaker. I similarly believe that we've had ample debate on this document, and no form of debate will shift anybody's position. We profile in reasons for which we are against that very clause in the Constitution. And with all of the debates, if we still stand our ground, then I believe even if we open another debate, we'll be here for the rest of the day. So I want to crave on your indulgence, sir. You are the head of this house. I want to crave on your indulgence, sir, that we proceed with the process. Because it's clear. One of the reasons one of our members stated is that even when you define consultation and you have a sitting president who does not go by it, who will reprimand the president for not knowing the Constitution, it will be a job in futility. So we still stand our grounds that we're against. We want that very clause in the amendment, and that position is our position.
So, the leader of government business, can you state your position and move a motion?
Mr. Chairman, I have stated I have the Katoka provision with me. Our provision, during we are in the opposition, presented the SAT committee as it is, rejected by the then government in 2017. Both the Peter Tucker and the Justice Kawan, in blessed memory, both of them, that said, let us sustain the extant provision that has Rule 32(2) of the Constitution. Whatever definition we have to do, we will address that law in the Public Elections Act. I so move that we stay with the extant law.
Your position is that we stay in the extant law?
Yes.
Any seconder?
No second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it.
Mr. Speaker,
Yes.
we are looking at an important document, which is the Constitution. Firstly, I want to rise on the SO 46-1.
Order. All of you in the gallery. All of you in the gallery. Don't take part. You are citizens of the Republic of Sierra Leone. So you are right to be here. But you are not right to take part in what is happening here. Otherwise, I will withdraw your right and send you out. So please keep quiet and listen to what is happening here. At the end of everything, you can go to your members in their offices, you can go to their homes and tell them, SO2, oh, I like the way you talk today. But not here. Please, proceed, Honorable.
Mr. Speaker.
Sorry, leader, please.
Yes, Honorable.
Yeah, Mr. Speaker, honorable members, time is 12. Yes, time is 12. So I move ISO 52 to suspend it for the business of the House to continue.
Yes, any seconder? Any seconder?
ISO second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it. Yes, leader of the opposition.
Yes, I rise on SO 46-1 to challenge your ruling, sir, and let it be on the records the number of people who voted in favor. And Mr. Speaker, this is about altering the Constitution, and I'll come to that. But firstly, I stand on SO 46-1 to challenge your ruling.
Thank you very much, Honorable Leader of the Opposition. So I'm going to put the question again, and I'll rule. Yes, Leader. I'm putting the question again. Hold on.
Yeah, Mr. Speaker, before you put the question, my challenge is as a result of the fact that I am not convinced with the collection of voices.
Yes, that's why I'm putting the question again the second time. All those in favor say aye. Those against say nay.
Mr. Speaker, Mr. Speaker,
Yes, proceed.
honorable members, of course, you do not need to have a very loud voice to vote in Parliament. Because if it were that, they would have gone to look for those with the loudest voice to be elected in Parliament. Parliament is a house of procedure. We have seen and noticed that during the process, there is immense participation from the gallery.
Now by simple majority.
Mr. Speaker,
No, they can't stand in their position accounts then.
that is why
Yeah.
I want us to have a head count so that we can have a
Until we reach
specific
the
number of members of parliament who voted for and those who voted against. That is why I am standing again on SO 46-1 to challenge the voice of leadership.
Honorable members, a division has been claimed by the leader of the opposition. In the circumstances, I call both leaders to call their members who are outside to come in. I'm giving you 10 minutes to make sure all your members are here. 10 minutes, Sergeant at arms. Sergeant at arms.
Yes, sir.
Clear the chambers. All strangers leave the chambers.
Mr. Speaker, yes, I want to appeal that we do it in the view of the public. Yes. See?
We are already online. I will allow Identify your members. The head of the press gallery, identify your members.
So we're still in Parliament. We are bringing you live features to the Constitutional Amendment Bill of 2025. And it's very clear that the Speaker of the House of Parliament has already ordered visitors to vacate from within the four corners of the Well of Parliament, including the gallery. So the only members who are allowed to stay are members of Parliament from both eye of the House, the SLP and the APC, and PCMPs, parliamentary members of Parliament, together with party supporters who are here to support their party. I mean, senior party stakeholders who are here to support their parties from both eye of the House, and similarly to members of the press. These are the only ones that are allowed to stay. The reason behind same is resulting from votings that were done in the House, a short while ago. Members of Parliament were requested to vote via their voices, and so the minority leader from the APC, Honorable Abu Kabo, moved Standing Order 46, wherein he did say that he's requesting on the Speaker to ensure votings are done via head count rather than voting via the ayes and the nays. Because according to him, his argument is you cannot determine a majority of votes via voices. And this is largely as a result of the motions that were moved on provision on section 32B of the Constitutional Amendments Bill. Sections 32B of the Constitutional Amendments Bill. That's more the reason why the votes are going to be held. And so, by the provisions of that sections, it reads, Section 32 says, Section 32 of the Constitution of Sierra Leone, 1991 Act number 6 of 1991 is amended by, in subsection 3, it reads, by repealing and replacing the subsection with the following new sections. So the 3 of that subsection reads, the President shall, where there is a vacancy in the office of the Chief Electoral Commissioner or member of the Electoral Commission, appoint a search and nomination committee for the purpose of nominating the Chief Electoral Commissioner or members of the Electoral Commission, comprising one person from the interreligious community, one legal practitioner who shall be persons qualified to hold office as judge of the High Court of Sierra Leone, one person representing civil society, one person from the private sector, Labour Congress or Employers Federation, one media practitioner in Sierra Leone, one person representing youth groups, and 3 persons representing women organizations. So, however, the argument is this. From the end of the ruling SLPP, the submission is that why having a search and nomination committee that the president will not be bound by? Why having a search and nomination committee wherein even when they will have selected, they will have made 3 nominations to the president is not bound by the nominations that will be put forward to him. And again, the fact is, it is a responsibility that the president can handle all by himself, while reducing the powers of the president through the conduct of a search and nomination. So that's the argument here this morning, and that's more the reason why a motion was raised, and so members of parliament will now vote on this motion via head count rather than them voting on the said clause or the said provision through voices. But I'm still here with my colleagues who've been following the engagement here this morning. Emmanuel Nyakemomo, things seem controversial here this morning,
exactly.
But it's provided for by the laws, it's provided for by the constitution, and even by the standing orders, that where votes, that voting in parliament could take several forms. Exactly. It could be either by voices, the ayes and the nays, or it could be by head count, or they could go through the ballot box. Emmanuel Nyakemomo.
Indeed, Samuel, it's really very exciting as well, forward-looking, and of course, I'm also very keen of the fact that the members of parliament of the APC are around, and I have just spoken to a member of parliament, of course, AKK. I asked him if they are going to vote. They said yes. It depends on the clauses. Currently, they are on the search and nomination clause, and that has also been very controversial, especially when the president has to appoint the search and nomination committee. But they have actually shown interest as to whether or not that clause should be part of the amendment bill.
But from the argument of members from the SLPP, they are like, why take a power from the president that he can handle by himself? Because the fact is, through the search and nomination committee, comprising members from several walks of life, they could appoint up to 3 members, and the president is not bound by the appointments that are made by this search and nomination committee. Why waste time? I think that's the argument.
I think the other argument here is that the president really, his hands should be off on the appointment of the members of the search and nomination committee, because the idea of the search and nomination committee is from the tripartite recommendations. So the APC is not really against the entire idea, but they just don't want a situation where the president will have a great influence on the appointment of the electoral commissioner. And of course, they believe that the ECSL is a very strategic office, and they believe that it should be independent. So that these are concerns coming from them.
Essentially, from the minority leader of the House, Honorable Abu Kagwe, said he wants this to go down the records. He wants this to be recorded. The fact is, they as members of parliament, that's one reason why he evoked Order 46 of the standing orders, which seems the guiding principles for members of parliament. But the fact is, it is the case currently in parliament, wherein the speaker has already ordered that every other visitor within the house excuse the well of parliament, inclusive of the galleries, with the exclusion of members of parliament from APC, the SLPP, senior party members from the APC, and senior party members from the SLPP, and also us members of the press.
I'm also impressed by the clerk so far in terms of the level of dexterity that he's showing currently. And I have also observed, because I went out as well, the security is really watertight here. But I will also tell you that there is amicably, the situation here is very peaceful at the moment, Samuel.
Things seem very peaceful. By the time we listen keenly as to what the Speaker of Parliament is saying, he's addressing the House.
Our political leaders occupy the diplomatic gallery. Please leave this area. I'll allow you to occupy the diplomatic gallery. All party stakeholders go up the...
And our party stakeholders from both eye of the House have been instructed to, because of the fact that votings of such nature are very critical, so they've been asked to take the gallery. They've been asked to vacate the well of the House,
The chairman,
they've been allowed to vacate the house, I mean the well of parliament, and then take the chamber. So it is the chairman of the political parties and their secretaries, former chairman and former secretaries, are the ones that have been asked to take the gallery. It seemed controversial here. The leader of the opposition is saying this is not a secret society.
this is my chambers. I don't think you should be arguing like that. This is my chambers. And even for I think we had another vote. Is it for the Auditor General? Yes, we also sent everybody out. No. Okay, this time we don't want strangers within the well. They can go. That's why I told them to go. Please leave out the opposition.
Mr. Speaker, with all due respect, sir, I'm appealing that you add to their numbers.
Mr. Speaker,
Okay.
We have 5 for each police.
Add to their numbers.
Yeah, we have 5 for each police.
Okay, 5. 5 from either side.
Yes, sir.
5 from either side. Go up to the diplomatic. 5 from either side. 5 APC, 5 SRP. Go to the diplomatic gallery.
Already pleaded that 5 allow in the chamber, whereas the remainder are asked to go to the gallery. But however, following the rule from the Speaker, the honorable member for Falaba, Honorable Mohamed Bilasso, has asked that because there are other members from other political parties, so therefore they should also be allowed. But the Speaker said he hasn't seen any member from any other party. But the House seem jam-packed. The House seem well represented at the moment, as we've seen from the gallery, senior government ministers and also party supporters from the SLPP and the APC. A number of government ministers are here. A number of government ministers are present here this morning. To show support to the process. But however, we're still here waiting on the directive of Speaker through the clerk, as we wait the commencement of the voting on sections 32 sub 3 of the Amendment Bill of 2025, which squarely hinges around the Search and Nomination Committee that has members that will be appointed by leader
of the opposition. Do you know why this is done? It is done for the security of members.
So the Speaker is just cautioning.
Do you know that?
The Speaker is just cautioning
at one point in time, recently,
the leader of the opposition, Honorable Abdul, that his decision is done for the protection of members of parliament. I think the security of members of parliament seem extremely paramount here this afternoon.
Yes, I think I also, like the leadership of the Speaker, for the very fact that he's ensuring that the security of the members of parliament comes first. Of course, even in the Constitution, we have a right to life, which is an inalienable right. It's only when you have a right to life that you can think about other human rights, Samuel. But I think the APC members of parliament are just very keen about the big elephant in the room, which is the PR system, that clause on the proportional representation system. I believe that will be the time as to whether or not they are going to vote or not. But it's very important that they have actually started voting for some clauses, especially the search and nomination clause. But I'm sure, Samuel, I speculate that there's going to be a huge problem on the threshold and the PR system.
Absolutely. You know, controversies of certain nature are one that you can expect controversies of certain nature more so with the manner in which things are done in Parliament as we speak. Tony Sawyer, things seem controversial here this morning.
Yes, and two, very, very much controversial. You know, the documents before the House is quite crucial, and we've seen even before today, see where the ruling bench was so stand on their position.
The argument at the moment is the fact that this is the People's House, and the argument from the APC is that this is there is absolute decorum, because that's what essentially the Speaker is working towards, ensuring that there is total decorum within the House, more so when votings of such caliber are happening. But again, the fact is, it requires, I think it's a simple majority at this particular moment.
All of the clauses will require two-thirds majority upwards. It will require a two-thirds majority before it's been passed.
And two-thirds majority is something like 99.3%. Whereas as it is, the ruling SLPP has about 81 members. The main opposition APC has about 54 members.
And it should be well noted that two of those
54 members seem to have been on the other side. They seem to have been on a frolic of their own. Yes. Honorable Mohamed Bangura and that of Honorable Thompson, they seem to be on a frolic of their own. We have 14 Parliament Chief Members of Parliament, constituting about 149 in total. Is that not the case, Tony Sawyer?
Yes, that is absolutely the case. But what we are hoping to see, or what crucial experts are envisaging in this voting, is that lobbying will see the victory. Like you said, there are 14 MPs, 14 who are on the two opposition members of Parliament, Mohamed Bangura and Alfred Thompson. Their position are quite uncertain in this voting. So we'll see an instance wherein they will be lobbied, except one of the benches will have to garner the support of the PC MPs, that they will have to be able to pull out this two-thirds majority. But it's clear that the opposition does not have the number, but the ruling bench will have to lobby around probably to get the number.
I think lobbies seem to watch what at this moment. 14 PC MPs, Parliament Chief Members of Parliament, that are to be lobbied by either side of the House to ensure they clinch the two-thirds majority. It seems impossible at the moment from both sides of the aisle, to grab the two-thirds majority.
Indeed, Samuel, I believe that's where actually the controversy is at the time. But like you said, lobby is very important. I just don't know how the leadership of the Speaker had been really very instrumental on this area, so that all the members of Parliament can be unanimous on voting for most of these clauses. But what is also very important, Samuel, gentlemen, is of the very fact that the citizens should be very enthusiastic in all of this that is happening, as to whether or not the members of Parliament are really seeking the interest of citizens.
Interestingly, on that end, we've just had the Speaker of Parliament asking the ECSL head and his entourage to take the gallery, because according to members of Parliament, they say they are ordinary men. They are they are reasonable men. They are reasonable men, and so they are not. They shouldn't be in the chamber where sessions are held. But the fact is, the speaker just informed the House that votings will be held in 2 minutes time.
Yes,
it's getting tense here in the House of Parliament.
It's getting tense, like, but I love the very fact that the Fourth Estate, for example, the media is very respected here, and of course we have been given the opportunity to be here in the gallery. This actually justifies the fact that there is democracy and good governance going around in the country, and it also speaks much about the freedom of speech, which is also in Act number 6 of the 1991 Constitution. And it's very important that the Speaker really had to make the decision that colleague members of the media are supposed to be in the well, amidst the fact that, of course, former members of Parliament are supposed to go up as the gallery. When the media is here, because the media represents the people, I believe that credible information will be communicated to the people of Sierra Leone. This is all about the people. Now, for the people, then we're all there, and we all really need to communicate to the people, and the people then really need to understand what's in the happen today, when it comes to the constitutional amendment, Samuel.
This is something, as you already mentioned, this is not something we need to change over time. You need to change the constitution when you're happy, and you need to change it when you vex. Now that my lecturer tell me the other time.
One thing I'd love to bring up to viewers at this time, Samuel, is the interpretation of the word in Parliament and out of Parliament. I mean, that will soon darken the conversation, because the Speaker will definitely have to explain what does that mean at this material time. Whether in Parliament means those seated within the House or those actual 149 members of Parliament.
I think that was why the reason why he called on the leadership from both sides of the House to ensure that their members who are outside the well should come in the well of Parliament, just so that the counting process will commence. But it seems this is indeed the moment every other side have been waiting for. More so when counting will soon commence.
It has been also a very busy moment for the Attorney General and Minister of Justice. And I see him seated, but he's also moving, going through and fro, ensuring that things are in place. I think he's having a keen attention.
Okay, I think the debate is about
the leader of government business.
Voting are about to commence.
The provision in the extant law remains, and that the definition of consultation be done in another act. All those in favor say aye. Can you please stand in your place? Those in favor, can you please stand in your place? Can you count it?
So the Speaker has just asked that all those who are in favor of this law to stand and be counted. But for those who've just stood up to be counted, these are inclusive of Honorable Mame Bangura and Honorable Thompson, who are members of Parliament, members of Parliament from the main opposition APC. But also, we've seen a number of Parliament chiefs who've also stood up in support of this clause, which is sections 32 sub 3 of the Constitutional Amendment Bill of 2025. And so the counting, they're currently counting those who've stood up. But by the looks of things, as mathematically, it should be 99.3 to constitute the 2/3 majority. On the background, you hear Honorable Aaron Aruna Koroma saying the totality is about 96 with the absence of a Parliament Chief Member of Parliament. But the countings are ongoing. You see a majority of the PCMPs they've stood up to ensure they are counted. And the clerk will soon announce the number of votes in favor of that motion.
Please stand up in your seats.
And they've asked those who are against the motion to stand up. Those who are against the motion have been asked to stand. From the seats of the APC, you see a seat is empty. You see some seats. Yeah. So, just been informed 2 members of parliament from the APC. 2 members of parliament from the APC are absent because 2 of their seats are absent, largely as a result of them being ill. And we're waiting on the clerk and his team to announce the vote. So as I just mentioned, 2 seats from the APC end seem empty, and the clerk is working majestically, counting the votes. Seem a very busy week for him. Seem a very busy day for the clerk of parliament. Seem a very busy day for him, Tony Sawyer.
Sorry, so it's a very, very busy day. I mean, these are the times you don't sit in your cozy atmosphere, and then, it's amazing. Like Honorable Aaron just intimated the press that 2 of the opposition members are unwell and they are unable to be there. So that means it's 50 members of the opposition and 1 paramount chief is absent. As you can see, his seat is there totally empty.
Yes, indeed, 1 paramount chief is absent. It's by Shebra. By Shebuam Bere III, who is absent. His seat is empty. I think 2. No, by Shebra is present. It's 1. By Shebra is present. The other one I've just seen by Shebra is from Lunge. It's from Lunge, and so 2 seats from the NFAPC is absent. And yes, so we're waiting on the clerk of parliament who did the counting, and he's taking down the records. And the records will be announced. And
Mr. Speaker, honorable members, the ayes 96, the nays 49.
And so it seemed clear that the counting is one which isn't done say by the provisions in section as per a 2/3 majority of the votes cast.
Yes,
that seemed the case. I think it's just the count is done majority.
By majority. Maybe it's because of the clause that they are dealing with.
In fact, it is the stage that encompasses the real process of changing the constitution or amending the constitution. This is the stage where we delete clauses. This is the stage where we insert new clauses. This is the stage where we change the constitutional wordings. This is the stage where we substitute previous provisions. This is the stage wherein we vote on the passing of those very clauses. And Mr. Speaker, Section 108 is very instructive. It says that for the amendment of the Constitution, so Section 108, which is an entrenched clause, specifically deals with the amendment of the Constitution. And Mr. Speaker, when you want to change is, you want to change at, you want to change a comma in the Constitution, it should be followed by 2/3 votes of members of Parliament. Mr. Speaker, let me go to 1089. Let me go to Section 1089, Mr. Speaker. It's very clear. It says Section 1089. It says, it should be supported by not 2/3 of this House. Especially the one that relates to subsection 1 of section 91, which states except where it is stated, the voting of Parliament shall be by simple majority. But in this case, the exception holds, because we are dealing with section 108, which has to do with amendment of our governor, which is constitution. So, Mr. Speaker, I take the greatest exception, and we on this side take the greatest exception on the fact that this constitution should not be amended, or no clause must be changed, or no letter must be changed, or no sign must be changed, be it in committee stage or in third reading with less than 2/3.
Just one more position by the leader of government business, and I'll rule. Yes, leader of government. Mr. Chair. Except probably you have more. Okay. Yes. Then I will listen to Honorable the leader of government business. I will listen to Honorable Givao, Honorable Daniel Kroma. Okay. Then I will rule. Yes.
Mr. Chairman, based on my standing here, Mr. Chairman,
yes.
Based on my standing in the House, I want Givao to talk before me.
Okay, Honorable Givao.
Yes.
Thank you, Mr. Chairman. Mr. Chairman,
Listening to the
Police, it's a very crucial moment. Okay, how about all on on this side? Yeah.
Listening to the submission of the leader of government business, we all have to acknowledge that we are making law. This is not engineering. And in making law, you look at the text of the very law that guides the lawmaking that you are making. I refer you to the very section that you made reference to, section 108, subsection 2. And we read it carefully for the public to understand. Thereafter, I will take my seat. Mr. Chairman, honorable members, section 108, subsection 2, which my colleague has acknowledged, that deals with non-entrenched clauses, state thus: a bill for an act of parliament under this section shall not be passed by parliament unless A, before the first reading of the bill in parliament, the text of the bill is published in at least 2 issues of the Gazette. That has been done, provided that not less than 9 days shall elapse between the first publication of the bill in the Gazette and the second publication, and B, the bill, this is the most crucial part, the bill is supported. It did not say the clause. It did not say the clause. Take note, emphasis 9. The bill, that is the entire bill. The bill is supported on the second and third reading by the vote of not less than 2/3 of the members of parliament. My submission, Mr. Speaker, members of parliament, it is my submission that we are at the committee stage, wherein we are voting on clauses, clause by clause voting, and as such we are guided by the provisions in section 91(1) of the 1991 Constitution, which I shall read as well. Section 91 reads thus: Section 91 reads thus: Mr. Speaker, honorable members, Section 91 reads thus. Okay. Except otherwise provided in this Constitution, any question proposed for decision in Parliament shall be determined by a majority of the votes of the members of Parliament and present and voting. Majority, emphasis 9, which means simple majority. So I will emphasize again for the members of Parliament that are following, when we are voting on clauses, we are not voting on the bill holistically. When we get at the point where we have to vote on the bill, I will concede to your point that it has to be a 2/3 majority. But now that we are voting on clauses, you go by 91, because a clause and a bill are different. My submission.
Thank you very much, Mr. Speaker. Mr. Speaker, before my intervention, I just want to ask a simple question to the honorable members' submission. Simple question to the honorable member's submission. The honorable member from Kailam. Just a simple question for the layman understanding and for the attention of the public, for the attention of all Sierra Leoneans in and out of this country. Just one simple question. Sierra Leone is made up of 14 districts. True or false? True.
14 provincial districts.
14 provincial districts. Sierra Leone comprises of 14 provincial districts. True or false? True. Right.
Honorable members, please, let me crave your kind indulgence. This is a very serious matter. Please, I'll crave your kind indulgence. You know, when people debate on this side, please let's pay attention so that we get the public to hear what we are saying. Please, it's a plea from me. Yes, proceed.
14 provincial districts constitute the nation of Sierra Leone. Simple question for the layman understanding. If there is border disputes in one of those districts, by another neighboring country, of which during that dispute, members of our district bordering that neighbor country are being killed, are being maimed, are being raped, is it a problem of Sierra Leone or not? Let's say, for instance, Kwanedugu. I came from Kwanedugu, and I represent Kwanedugu. Kwanedugu borders Guinea, and Kwanedugu is part of Sierra Leone. If Kwanedugu has problem with Guinea, and then the Guineans come and bombard citizens of Kwanedugu, rape the women of Kwanedugu, kill the people of Kwanedugu, is it a problem of Sierra Leone or is it a problem of Kwanedugu? It's a rhetorical question. It's a rhetorical question. You can answer in your mind. And your conscience can answer as well. The problem of Kwanedugu is a problem of Sierra Leone. And His Excellency the President is President of Sierra Leone, of which Kwanedugu is a part. Mr. Speaker, on that premise, I refer you to Section 91.1. Section 91.1. It reads, except as otherwise provided in this Constitution, underline that exception clause. Except as otherwise provided in this Constitution, any question proposed for decision in Parliament shall be determined by a majority of votes of the members present and voting. Mr. Speaker, you are a lawyer for no mean standing, and the honorable member from Gadaun is a senior, and he quite well noticed that this provision, subsection 1 of section 91, has an exception clause as an opening statement. That opening statement is not for nothing. The drafters knew what they were doing by providing that exception clause. Mr. Speaker, you would also agree with me, including my senior Debao, that in law, you have rules. Sometimes you call them general rule. You have general rule. And you agree with me that not all, but most of those general rules, some of those general rules has exceptions. There are exceptions to general rules. And in fact, apart from that, there's a third stage. You agree with me in the law of evidence that in addition to general rule having exceptions, you also have what we call exception to the exceptions. You have general rule, you have exceptions, and you have exception to the exceptions. Secondly, you agree with me. You agree with me that all exceptional clauses supersede the general rule. Exceptional clauses supersede the general rule. You agree with me? My senior knows that. That whenever you have exception, that exception is superior to the general rule. It's not affected by that general rule. It supersedes, it's more powerful, it's more superior, it's more potent than the general rule. Speaker, honorable members. Mr. Speaker, honorable members, I read the provisions of Section 108. But before I read, I want to inform this House that Section 108 is clearly, unambiguously an exception to Section 91(1). It's one of the exceptions to Section 91(1). A clear exception. It's very, very clear. Mr. Speaker, another exceptional clause in the Constitution is the law dealing with state of emergency, passing state of emergency. State of emergency gives exceptions. It gives exceptions to the powers of the president. The general rule sets limits to the powers of the president. It sets limits to the rights, the human rights of citizens and non-citizens residing in and out of this country. It sets limits. But Section 29 now came. You and I know that under Section 29, those general rules regarding your human rights, your right of movement, your right of speech, or this and that, the exceptions supersede those ones under 29. And the president has the power to overdo his general power stated in Chapter 3. The president under 29 has the power to overdo Chapter 3 of the Constitution dealing with basic human rights. You know that very well. Mr. Speaker, clearly, Section 108 is an exception rule. And I read, without further ado, I read paragraph B. Paragraph B of Section 108. I will first read the opening statement. Subject to the provisions of this Constitution. Subject to the provisions of this Constitution. When you say subject to the provisions of this Constitution, you can say reference to the provisions in 91(1). Because 91(1) is part of the Constitution. Subject to that provision in 91(1). Subject to any other provision. But I will refer you to the provision in 91(1). Subject to that provision. Let us stand there and then move on. Parliament may alter this Constitution. Parliament may alter this Constitution. Of course, may. Because it gives us the discretion whether to pass it or not. We have the supreme power under 105. You know that. May alter this Constitution. What constitutes alter? The verb to alter. Or the noun alteration. What do you mean by the word alteration? In this Constitution, any form of amendments, any form of changes, any form of importation from one act to this one, or taking it to another, or taking it from one chapter to another chapter, no, it's best fit under chapter 2 rather than chapter 3. It's best fit under section 9 rather than section 1. That's importation. And even by modification it says, but it reads now this way rather than that other way. It constitutes alteration. And that alteration points to single individual clauses, single individual provisions in each clause. It says that bill, the bill before us here, the bill before us is supported by the second and third reading by the vote of not less than 2/3 of members of Parliament. Now listen. Now listen. subsection 8 of section 108 for further edification. Subsection 8 of section 108. It reads, maybe I will only stop to the opening paragraph so that I will go to the others. Or if you don't mind, I will read all. Subsection 8 of section 108. Speaker. Mr. Speaker, honorable members, subsection 8 of section 108. It reads, any suspension, alteration, or repeal of this constitution other than the authority of parliament. Thank you, Mr. Speaker. Mr. Chairman, I will start fresh. Any suspension, alteration, or repeal of this constitution other than the authority of parliament shall be deemed to be an act of treason. Now I want you to pay careful attention to this one. That to suspend, to alter, to repeal, only parliament can do it. So now we are dealing with alteration. We are not suspending. We are not repealing. We are dealing with alteration. This alteration now goes, in fact, on 3, goes further to say that even references alone, by just making a reference, to a particular provision of the Constitution, amounts to alteration. But I will read for edification. References to this Constitution include, listen to this, references to this Constitution include references to any law that amends, replaces any of the provisions of this Constitution. I will repeat this one. References to this Constitution includes, underline the word includes references to any law that amends or replaces any of the provision of this Constitution. Mr. Speaker, without going further, when you talk about provision, a bill is not a provision. A bill cannot be described as a provision. Provision refers to individual clauses. Provision refers to individual clauses. Individual clauses. Mr. Speaker, honorable members, in fact, this one, you don't need to pass again. You don't need to pass again to understand this mathematics. Let's say the bill has 9 provisions. 9 provisions. I've told you what provision stands for. A bill cannot be referred to as a provision. Provision refers to individual clauses in the bill. Now let's say for instance, you have 10 clauses. in a bill. 10 clauses in a bill. And then you say, this is for layman understanding now. You say, those bills gathered together need 2 thirds. Those 10 clauses gathered together are called a bill, are being referred to as a bill. And until it is treated as a bill, before it requires 2 thirds. But on the contrary, those 10 provisions, in order to pass each, you just need a simple majority. Now let's go this way. The Constitution says you need 2 thirds. For the 10 clauses put together, you need 2 thirds. And then you are saying each can go by simple majority. So let's say now, we'll go to the first clause, number 1 clause, simple majority, passed. Number 2 clause, simple majority, passed. Number 3 clause, simple majority, passed. Number 4 clause, simple majority, passed. Number 5 clause, simple majority, passed. Number 6 clause, simple majority, passed. Number 7 clause, simple majority, passed. Number 8 clause, simple majority, passed. Number 9 clause, simple majority, passed. The last and final clause, number 10, simple majority, passed. And now you all come now together. So well, from 1 to 9, you need 2 thirds, and then the bill cannot pass 2 thirds. Does it make sense? Does it make sense? Does it make sense? If you can go from 1 to 10 by simple majority, and then there's another bridge to cross, and that bridge now, the law says you need 2 thirds, and then you cannot cross that bridge. So why waste time? It proves that that is not the intention of the drafters at all. At all. Mr. Speaker, the word passed. The word passed. Am I protected, Mr. Speaker?
Proceed, Honorable Daniel.
Thank you, sir. The word in law, passed, in quotation, passed. You know what it implies? It implies finality. It implies finality. Finality. When a bill is passed, it means it has come to completion. It is now law. That's the legal meaning of the word passed. So let me ask you this question. How can you apply the word passed to a clause? Clause 1 passed. Clause 2 passed. Clause 3 passed. Clause 5 passed. Clause 10 passed. And then all bundled together, all 10 come together, they cannot get 2/3 majority, and then it's not passed. So the word passed in law cannot apply to individual clauses. It cannot. Under section 108, the term in law passed cannot apply to individual clauses. Simple majority cannot apply to them. Because under section 108, they cannot be passed in the absence of 2/3. Let me tell you one. Mr. Speaker, section 108 is so selfish. Very selfish. Selfish. I've never seen a selfish clause or a clause selfish than section 108. Selfish. So section 108 sees itself as so important. I am everything. Without me, you cannot live. And everything starts with me. It starts with me. Everything starts with me. Mr. Speaker. Thank you, sir. Mr. Speaker, I refer you to subsection 3. Subsection 3, paragraph A. I will read the opening subsection and then I will stop at paragraph A. Subsection 3 of section 108. Subsection 3 of section 108. Paragraph A. But I will read subsection 3 for better understanding. Say a bill for an act of parliament enacting a new constitution or altering, remember altering, any of the following provisions of this constitution. That is to say, now I will read it again because I want you to understand. A bill for an act of parliament enacting a new constitution, listen, or altering any of the following provisions of this constitution. That is to say, number 1, this section. Section 108. That is to say, me. If you are given 10 oranges to share between 9 people, if you are wise, what will you do? The first orange belongs to who? Me. And then I will share the rest. The first law of nature is self-preservation. So 108, respect the law of nature. Me first. And when the act says this section, number 1, I mean A, paragraph A, this section, it means which section? Section 108. And section 108, paragraph B of subsection 2 of section 108 is part of this section. This section. And then it goes to outline the rest, the others. But it starts with this section. This section includes all of section 108, all. And what this section says, that is why I see section 108 as jealous. He's very jealous of himself. Once section 108 has spoken, section 108 doesn't want any interference, no interference. This section now says, in paragraph B, say it is supported at the second and third reading by the vote of not less than 2/3 of members of parliament. That is part of this section. It is not part of intent clauses with requiring referendum. No, it does not start there. It doesn't start. It started with himself first. I'm saying himself because I see Dr. Wawere as a human figure. Human figure jealous of himself and very selfish, and he will not tolerate anybody to tamper with what I have spoken. This section. Mr. Speaker, honorable members, in fact, this is for common sense now. For common sense. Our body is made up of so many parts. body is made up of so many parts. You have your hand, you have your feet, you have your stomach, you have your eyes, your heart, and the rest. At the point in time, the head, the eyes, the hands, they revolted against the stomach. They revolted. Say when me as the hand, I walk, I use the pen and write. The eye says, in fact, I see, I direct you. The brain will say, in fact, I gave you the idea to modify, to make sure, to make sure it is appealing to your examiner or to your awarding contractor or to Mr. Speaker for approval. At the end of the day, when you get your salary, when you get your money, you buy food under the stomach. Enjoy. So the hand says, I will no longer work. The eye says, I will no longer see. I will rebel.
Mr. Speaker, point of order, please. My colleague, please. Mr. Speaker, Mr. Speaker, I know you are the president of this world. I want all of us to be mindful of the principle of filibuster. I think that is what my colleague is doing. When the filibuster in a legislative process like this is trying to delay the process of coming to an end of a particular process. My colleague has been conducting.
You know, it's deliberate. You know why I'm allowing debate? It's deliberate.
No.
Because on this matter, when I rule, my ruling is going to take care of all the other clauses. So that's why I'm allowing debate. Because when I rule, that rule is going to take care of all the other clauses. So it's deliberate, please. Yes, Honorable.
Mr. Chairman, for the order of this House, I will not comment. For the order of this House, and for your respect, I will not comment. I will go ahead. These parts of the body went on strike for about 4 days. On the 5th day, what happened? On the 5th day, what happened? The eyes became dim, can no longer see. The ear can no longer hear. The hand can no longer walk. The feet can no longer take the body from one place to the other. At the end of the day, they all appeal again. Say, Mr. Soma, please, we are sorry. We are sorry for what we did. We're ready to support you now. And then, in the next 1 hour, the human figure started sweating profusely. And then energy re-energized. What I'm saying here, I'm making this illustration to prove to us that Section 108 is like human figure. You cannot divorce any part of the Constitution as being separate from the other. Touching one is touching all. Alteration of one clause is alteration of the Constitution. Right. With the alteration of that clause will not only change, but the entire Constitution will no longer be the same. It will change. Mr. Speaker, the legal meaning of text, T-E-X-T. The legal meaning of text. Text includes even a full stop. Even a full stop is a text. And changing a full stop to comma can change the meaning of that particular section. You agree with me? Changing a comma, changing a full stop, removing the full stop, and replacing it with comma can change the intent of the drafters of that constitution. It can change the overall meaning. Will change. Automatic. Even a beginner student will know that this particular clause does not mean the way it used to be. Based on the change of that text from full stop to comma. Mr. Chairman, honorable members, in my final submission, I'll present to this House that the bill before us is a package. The bill before us is a package. What do you mean by the word package? Package is a combination or inclusion or constitution of various segments. Various segments come together and form a package. If one of that segments is removed from the package is no longer the same. I don't know anybody here who used to smoke. I don't know anybody here who used to smoke. Or who smokes as I speak. But for those who used to smoke, or who smoke right now, in my days, we used to call a cigarette package Western. That Western, it has 24 segments in the packet. 24 in the packet. 24 in the packet. You remove one stick from that package, it's no longer a full package. Can no longer be referred to as a package. It's not. If one is cut into half, one cigarette stick in that package is cut into half and then inserted again with half. The rest full stick. The one half stick. It's no longer a package because the package has been altered. Mr. Speaker, above all, we are here speaking our minds, speaking on what we know for posterity. And if we are 200 in this world, I want to inform you that there's a 201 person. There's another person that constitutes also 201, and that is who? Almighty God. Almighty God is here listening. And there's what we call God in us. God in us. You have God in you, your conscience. Our conscience knows very well that section 108, paragraph B of subsection 2 of section 108 cannot refer to clauses to be dealt with by simple majority. No. Each clause amounts to alteration of the Constitution and must need to dots. In the absence of which, Parliament may be abusing the powers given to it under subsection 8 of section 108. Because section 108 excludes all other walks of life, all walks of life. Only Parliament has the power to alter, to suspend, to import, to modify, to even make reference. So if we use that privilege given to us by subsection 8 of section 108 and misinterpret paragraph B of subsection 2 of section 108, it amounts to abuse of office. And it can even amount to treason as well. We cannot misinterpret. Otherwise, it will go against subsection 8 of section 108. Mr. Speaker, on that note, I must say that we on this side, we are for the Constitution. And we are not supporting any undue procedure that will misinterpret the provisions of section 108. The people of this country are listening to us, and they all support the true meaning of this particular provision. And it allows 2/3 majority to change anything. Otherwise, anybody can wake up one day and then just change anything with no issues. It will be easily abused by allowing simple majority. Simple majority can never apply to this section. And when I say this section, I mean section 108. This section applies to all, not the settlement. And that's my case for now. Now process the question.
And then give my ruling on this matter.
Thank you, Mr. Speaker. I've listened to my colleague on the other side, the Deputy Leader of Government Business, and the Deputy Leader of the Opposition.
Thank you for your promotion.
And I'm happy he happens to be a lawyer, and he's a long-winded lawyer. But I'm sure during the course of this process, he has not been paying attention. If he has been paying attention, he will realize and recall. I am not attacking him, I'm just saying, please, please, today's
Make your point.
Paying attention is not an insult, it's not an abuse.
The Honorable from Kalau made some statements, but I said for your respect, let us respect you. You think I cannot respond? Something came in my mind, but stop with that word, you will regret. But I said for your respect, I will ignore you. Let us respect you. By attacking me, it will make this for us, and then that's not respect for you.
Thank you very much. Members, let's be careful. Let's find our words.
Mr. Chairman, I will still stand by my words. I know not paying attention is not an insult. Not paying attention is not being attentive. Period. And this House called that in the course of the passage or the review of this bill, when we discussed section 76, myself and the leader of the opposition were against the extension or the enactment of 12 months as the period specified in this constitution for a civil servant or anybody prescribed by this constitution to resign. However, Mr. Chairman, you asked for a vote and we voted, and in that vote we were defeated by simple majority and a ruling was made by Mr. Speaker. Mr. Chairman, I have said this process is bent or depends on the fact that we have to be honest. This is the Constitution. The other document is a proposal, a bill, which is not the Constitution as provided for in Section 108. A proposal before Parliament can never alter this Constitution, whether it is dealt with clause by clause or not in the committee stage. It will never change the intent, spirit, and purpose of this Constitution until it gets to the third reading. Mr. Chairman, how can a proposal be treated and he has read? And I'm sure he understands subject, verb, agreement, he understands the subject, the predicate, and all. So he should understand the fact that the emphasis on paragraph B and the very subsection 2 of section 108 starts with the word the bill or a bill. How can a simple clause that is not in this Constitution, that is a proposal that is presented before this House, end up as a factor to change this Constitution before it's done here? It is never possible. So the drafters of this Constitution, they knew that the fact is you can do anything at any stage, but at the third reading, before it has the mandate of Parliament as provided for by subsection 1 of section 108, that Parliament may alter it. Before Parliament alter it, it must have the consent of 2/3 of members of Parliament at the third reading before it is passed into law. But how can a proposal at this committee stage form part of the bill? I heard him say that if you take a stick of Western, by the way, those of you who are very young, it's white packet, it has a horse, it has a red background. My mother was selling cigarettes. I had his description of Western, and I will also draw his attention to two examples. The first is those that attended Jala University will tell you that they will sit in the first year, in the second year, and in the third year, but they will never get a degree until they pass the comprehensive examination. Mr. Chairman, those who are teachers and those who start to the NCTV exams before they have the opportunity of going to college, I'm sure you will pass all of the exams at Michigan or whichever of the NCTV constituent colleges, but you will not have the NCTV certificate that will qualify you for an application for any university until you pass the comprehensive NCTV exam. So if he's talking about common sense, I think common sense should apply pari passu. Common sense should apply pari passu that a clause that is not in this constitution and is a proposal brought to us by a minister of government can never enter or have its way in this constitution until after the third reading, Parliament takes a vote of 2/3 on the bill as provided by Section 108. So for me, I see this long-winded, skewed conversation as a way to try to play to the gallery. And we have passed that. We have been on radios, public radios, national television. We have taken a debate. At the magnanimity of Mr. Speaker, even during the committee stage, when we are discussing clause by clause, you allow a debate also to ensue. I think that is sufficient. And Mr. Chairman, this House will continue to rely on a source of law, which is President. And the President has been taken on this bill. We have voted on a clause that forms part of this proposal. And that clause will not pass until in the third reading it is voted for by 2/3 of members of Parliament. That is when that clause that was proposed during the second reading would become a law for this country. Mr. Chairman, we rely on your wisdom and we want to progress so that we complete this process as fast as possible.
Mr. Speaker, honorable members, I can't really understand the story. What is before us is a bill. Mr. Speaker, what is actually before us is a bill. For you to pass, I am not going to read the provisions. You know, Mr. Speaker, I guess you read jurisprudence, Jurisprudence, you read that one. It's the logic, the origin, and the underlying theories of the legal system. That is jurisprudence. I was at private college, I was in the law student. It's a very difficult subject. I mean, that's why it's difficult to pass. I know Mr. Thompson is around, and Dr. Wright, I know they are around. You must be watching us. Oh, Dr. is here. Mr. Thompson, you are here. And Ronald Wright will be watching us. The man who used to admire. I did some logic. In composition of a sentence, you have the word. The word constitutes what we call sentence. And sentences, when you constitute them, makes up what we have a clause. And those clauses make up sections. Those sections omit to have what we call a game. Simple. So science of philosophy is what we call jurisprudence. Science of philosophy. Science of philosophy. So I'm thinking that the interpretation, going around, merry-go-round, interpreting things, going through this, we are not new. It's not the first time we are amending this constitution. We have done it, simple majority, at the committee stage, clause by clause. Mr. Chairman, it's very clear to us, in this famous section 108, we are quoting, trying to confuse people. We cannot be convoluted with this whole thing. We can't allow you to confuse us. As I said, I know where they are coming from, and I see them giving us their back at the end of the ruling. This has to do with the future of this country. The bill is what we have. We are continuing to pass it. Instead, for you to pass this one, the bill, it is a bill. The topic has bill. It has to take 2/3. We have done collection of voices in the second reading. We are not at the committee stage.
We are not approaching a third stage where we are going to put questions, we do division, and we come now to vote to get 2/3. For clauses, what I explained. It's 91, simple majority. We have done this times without number, over and over. Sometimes these lectures can be very unpalatable to us. When you may go around without making a logical conclusion, you have failed jurisprudence. You have failed jurisprudence. Mr. Chairman, for us on this other side, I still sustain our position. And people are explaining sincerity of the law. We have to express that one. This 32 we are talking about for the consultation for this, we want the instant provision to be maintained. That's the provision they agreed in June 2017. That was agreed upon by late Justice Kawan's report. We have it here. You all know we have debated over and over. So we are not filibustering here. We just want the people to understand that what we are doing is not the origin. That's why I said jurisprudence. The origin is not coming from us. It's not coming from President Yu. It's coming from the former administration and also the late Pataba of Blessed Memory. What we are doing, we want to put finality to this process. So I don't think if you are teaching law subjects and simple English, this is pretty big. And we said, I've said over that this time, clauses, constitutional support, put it into sections, all of these makes up a bill. So we are sanitizing this bill. But when you want to pass it into law, all this issue of alteration, no alteration, for now, it doesn't make sense. If you don't take a 2/3, it's no law. If you don't take a 2/3, it's no law. So when we cleanse or sanitize the clause by clause, we are going to put a section to these sections, and you put a final question. That is why, even in the 2/3, you have to claim division. When we are at the second reading, you put the question, and we did collection of voices. No dissent review. That is 46, and you have claimed 46. It's not a bill. We said clause. If you are talking about a bill, you should have talked about let us go directly. We cannot underscore the integrity of anybody. But let us make some sense out of our solution, or out of what we have in front of us. So, Mr. Speaker, as Honorable Deputy Speaker said, we don't want people to play to the gallery as if we don't know what you have committed for so long. I will stand here and speak over and over, but we want to put a logical conclusion to this business, to make sure that what we have in front of us, for now, indeed with simple majority, based on passing this particular committee, the process we have in form of simple majority. We have set all the provisions. I repeat myself by take my seat. 108 says 2/3 for the collection of the bill for second reading and third reading. The bill, it is said cannot pass if you don't have the 2/3 majority. What you are doing now is the clauses we are amending, and the clauses has to do with 81. This is not the first time. If they doubt it, I also encourage them to invoke SO 12 Hands Act. I'm not new to these things. We are dealt to them. Amendment of PPLC Act. We did amend clause by clause of this constitution. Let's go to the answers. That's why we have the records. Precedent. We have amended this constitution in the first parliament using collection of voices, even when people had dissenting view. The man you called to yourself in the truth, with all due respect to him, SPB, and Honorable Chairman Jubadi are also said here as Deputy Speaker. The passed amendment, the election of Speaker and Deputy Speaker, the collection of voices, when even they had challenges. We don't want to go 79. We don't want to go to the answer. But Mr. Speaker, Mr. Chairman, we are watching. What you are putting to the fore of this country is our sincerity of document we have presented to you. That June 2017, we all accepted to sustain this provision, section 32.3, that asks to do with consultations of appointing electoral commissioner. Thank you, Mr. Chairman. Thank you for the
silent.
Honorable members, I'm going to take my time to explain the reason for my ruling. I will take my time to explain so that everybody is able to understand the reason why I will rule in a particular way. Please, we're all members of parliament. Please take your constitution and turn to 91. Section 91, subsection 1 reads, honorable members, in fact, this particular section is not even written in serious legalese. It's written in plain language for all of us to understand. There isn't much legalese here. 91 subsection 1 reads, except, it starts with the exception, except as otherwise provided in this Constitution. Except the Constitution says otherwise. Except this Constitution says otherwise. Any question proposed for decision in Parliament shall be determined by a majority of the votes of the members present and voting. So everything we do in Parliament, all the decisions we arrive at in Parliament, except this Constitution says otherwise, will be by majority of the members present and voting. Now, because this particular section refers to an exception, I will tell you that there are exceptions in this Constitution. Now turn to section 29, subsection 3. Turn to section 29, subsection 3. Section 29, subsection 3, particularly B, but I'll read the entire section. Every declaration made under subsection 1 shall have A, I'm not bothered about A, but B. In any other case, sorry. Okay, in any other case, at the expiration of a period of 21 days, beginning with the date of the declaration, unless it has in the meantime been approved by or superseded by a resolution of Parliament, supported by the votes of 2/3 of the members of Parliament. That's one of the exceptions. One of the exceptions. You know, 91 subsection 1 says except. So one of the exceptions referred to in this Constitution is 29 subsection 3B. Now turn to section 119 subsection 9. Now, in section 119, subsection 9, honorable members, let me read. It says, the provisions of section 137 of this Constitution relating to the removal of a judge of the Superior Court of Judicature, other than the Chief Justice from office, shall apply to the Auditor General. Now, in this 119 subsection 9, reference is made to section 137. go to section 137. Now, particularly subsection 7. Now, 137 subsection 7 reads, a judge of the Superior Court of Judicature shall be removed from office by the President if the question of his removal from office has been referred to a tribunal appointed under subsection 5, and the tribunal has recommended to the President that he ought to be removed from office. B, if his removal has been approved by a 2/3 majority in Parliament. That is another exception, tied up to section 119, subsection 9. There's another exception. Section 137, subsection 10. Go to that provision again. Now, section 137, subsection 10 reads, the Chief Justice shall be removed from office by the President. Now, A says something. B, if his removal has been approved by a 2/3 majority in Parliament. I will also refer you to section 173. Go to section 173. Now, section 173 reads, now the provisions, I'll take my time to read, the provisions of any consequential provision act made under this Constitution and of any act relating to citizenship shall not be amended, repealed, reenacted, or replaced unless the bill incorporating such an amendment, repeal, reenactment, or replacement is supported at the final vote thereupon by the votes of not less than 2/3 of the members of Parliament. Now, I'm taking my time to make reference, to refer you to all of these provisions for you to know that apart from these exceptions, whatever decision Parliament wants to arrive at here is by the majority present and voting. Another exception is 108. Go to 108. Now go to 108. Now 108, subsection 2, particularly paragraph B. The bill is supported on the second and third reading by the votes of not less than 2/3 of the members of Parliament. Now, you see the law, especially codified laws that are written, you don't perceive them. You don't create your own perceptions about the law. Codified laws that are written, when the drafters want to say anything, they write it. I sense a whole lot of confusion about the Constitution. But when we come to the third reading of this Constitution, I will do a ruling. And that ruling will be referred to the Supreme Court for opinion. You don't create perceptions about the law. If the drafters mean anything, they write it. So apart from all of these exceptions, any decision we want to arrive at in Parliament is by the majority of those present and voting. Now, honorable members, that being said, let me also refer you to the fact that this document we have before us, of course, the Deputy Speaker went to a very large extent to speak my mind. This document we have before us is not the Constitution. Because I sense a whole lot of confusion around this. It is not the Constitution. This document is not the Constitution. And this document we have is what we call a proposed law. It is a proposed law. And whatever we do in this document, line by line, clause by clause, does not affect the Constitution in any way. The only time this document is going to affect the Constitution is after it would have passed the third reading. Then all the provisions there come into play automatically. The day we pass the third reading of this document, that is when all the provisions in this document come into play. Otherwise, this is just a proposed law. It's just a proposal. This document is just a proposal. You know, the drafters were crafty enough. They were so crafty. They know one important stage of this document is the second reading. Because after the second reading, then you go to looking at the big clause by clause, line by line, paragraph by paragraph. And they know at the third reading, then it becomes law. By dealing with any clause here does not mean we are amending, we are repealing, we are replacing any provision. In the first place, this one we just dealt with is not even in the Constitution of Sierra Leone. This such a nomination committee is not even in the Constitution of Sierra Leone. So you can't even begin to talk about 2/3 on something that is not even in the Constitution. In the circumstances, honorable members, I rule that our decision, clause by clause, will be by the majority present and voting.
Mr. Speaker.
Yes, leader of the opposition.
I so much respect you as a person. And my position has always been that we are living a lasting memory as a nation. This parliament is making a history. And we on this side totally convinced, we are extremely persuaded that you cannot change this to was and off to act in this constitution by mere simple majority. With every respect to your ruling, sir, as stated in SO 42, I want you and the general public, the entire world, to note that we on the side will not be a party to abrogating or going against the standard of amendments in our government. We have supported various reforms brought to this house. If we are not willing to support reforms, we will never have voted today. But what we did was an expression of our total willingness for government. But our willingness does not mean we should do what we consider as unlawful. So, Mr. Speaker, with all due respect, sir, pending on your ruling, we want the entire world to note that 96 honorable members of parliament are seeking to amend a document that is to be amended by 100 members of parliament. So we on this side cannot be a party to that, Mr. Speaker. So, honorably, sir, with all due respect, sir, I respect your office so much. I respect your office so much. And in fact, I am constrained because of the respect I have for your office. We on this side will honorably, with all due respect to your seat and with all due respect to this parliament, and the people of Sierra Leone who are watching us, people all over the world, we on this side will not be part of an amendment that lacks the threshold of 2/3 majority. So on that note, we are leaving the ball in your court. 96 members. If you want to touch the constitution, you have the ambience, but posterity will hold you responsible. So on that note, I ask my colleagues on the side that we take a peaceful leave and we leave 96 members.
Members of Parliament from the main opposition APC, they've just taken a position. They are singing their party song as they prepare to depart the Well of Parliament and leave the rest of the debate in the hands of the other members of Parliament from the ruling SLPP and a few other members, parliamentary members of Parliament, Emmanuel Nyakemomo.
Indeed, Samuel, I saw this coming initially, and of course, it's very succinct here that the APC members of Parliament have said that it doesn't really walk towards the threshold of 2/3 majority, the amendment decision that is about to be taken in Parliament. And so because of this, definitely they are leaving the well of Parliament at this moment because they believe that the amendment should not be done with a simple majority.
Indeed, that's the belief of the APC. The Speaker said he will take a position on this and will afterward refer this matter to the Supreme Court for an interpretation. I think this has been the bone of contention in regards to issues having to do with the provisions in the Constitution of Sierra Leone. It seems a problem as to the interpretations that are given to the Constitution many times.
Indeed, the Speaker had actually relied on several sections in the Act number 6 of the 1991 Constitution.
Commissioner is attain the age of 65. If you attain the age of 65, you cannot use 2 bars. In most legislations, in conformity with the law, for us to put two bars at the same time for one provision. So I'm moving that instead of saying he has not attained 5 years, running down to B of that one, if he has not attained same provision under the member of the Electoral Commission, unless he has attained the age of 65. So we are saying, okay, we leave it as it is. You cannot be qualified. I've done 2 submissions. What do you cannot be qualified to be a commissioner if they have attained the age of 65. That is one. But we are now introducing another clause that you have a term limit. A term limit of 2 years. Of 2. Yes. So I'm now. Take note, Mr. Minister. Mr. Minister, can you move? Can you move? Yes. I move that you cannot be qualified to be commissioner if you attain the age of 65. That is one. will come the rendition.
Yeah, the rendition will be done properly. Any seconder? Any seconder?
I so second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it. We proceed on page 4.
Mr. Chairman.
Yes.
We give you the rendition. I want you to be consistent with other provisions like that.
We have just passed it, we have just allowed it in principle.
In principle.
Yes.
So we come back to other rendition and we pass
Yes.
it.
Proceed. 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 Page 4. And okay, on page 3, there was this provision relating to if he is not a member of the registered political party. Are you maintaining that? If he is not a member of the registered political party.
Chairman, that causes no harm. We put it just to enhance the process of legislation to qualify, yes, registered. Well, I think we have to do, because there is a clause at the PPLC Act that has to do with a registered political party and active political member. So we are going to put a registered political party. We will check that out with the drafter. I thank God the drafter himself. Because they are speaking in two different languages. So when at a political party, a registered political party, I think we consult the drafter, we come back to that. Definitely we have to state it. Yeah, thank you.
Yes, Mr. Minister. Is that correct?
Yes. Yes, Mr. Speaker, Honorable members, that is correct.
Yes. Again, whilst I agree, Mr. Chairman, and I'll kindly play with the Honorable Leader of Government Business, whilst we're looking at that particular rendition, we also consider, because sometimes it's difficult for you to even put membership, we can talk about engagement in partisan activities.
Is all right. Is that noted, honorable members? Okay. Yes, page 4.
Chairman, I was expecting that Mr. Minister will agree that if masters for the qualification that if you have a postgraduate from a recognized university and has, that is 3, A, Chief Electoral Commissioner, unless he holds a postgraduate degree from a recognized university, 1, Roman 2, has a professional qualification and experience in governance and public sector, at least, for the Chief Electoral, at least 10 years. At least 5 years.
Yes, we did that amendment.
We did that amendment, yes, right?
10 years, no.
Yes. 10 years.
The others are 5.
The others are 5. And also for the bachelor degree, once you talk about postgraduate course in the Chief Electoral Commissioner, they can act in that capacity at any time. So why not just say the same qualification for the Electoral Commissioner? For B, the Electoral Commission, unless he holds a bachelor degree of equivalent from a recognized, I think I want to be consistent with the law. For the SPSS, the qualification for the National Security Act, there was a difference in qualification with that of the NS Corps and deputies, even for CISA. So we said no. You can act in that position at any time. For the experience as we have done here, you can understand. But because you are going to act and it has to do with some level of efficiency and professionalism, I believe that that has to go to the level of qualification. That's what I think it should have the same, for the consistency sake, the enhanced law. That has been my position from all the time.
And under clause 3, we were supposed to have inserted 61. Amendment of 61.
Mr. Chairman. Mr. Chairman.
Yes.
Yes, I just want to make a quick comment on the recognized university aspect.
So I don't know, there are some universities that are recognized, but then they are not accredited. So I don't know whether we say accredited or just recognized university.
Honorable Member, before the chairman comes in, I don't think this is something we have to belabor on because we've had provisions that clearly spells out when it comes to the qualification in terms of how we use that particular aspect when it comes to university. I don't think that will be a problem. Thank you.
Honorable members, I think we don't need to engage in further debates. Let's go to the issues as they are. Because I don't think there is much contention right now. So just go to the issues and move.
Mr. Chairman, let me understand. Just to be clear. We have legislations already exist for different institutions. They are part of, but we have to understand so we cannot come back to the because we cannot do the administration of the law.
Of course.
That's why we have our subsidiary legislations. But there is a reason I had to register for 180 terms of fixed election limits. We made an announcement that those legislations will be in front of all the PLC Act, the Public Elections Act, and also with the provision for the for regulations. So those things have been taken care of. University Acts are there. Whether you are accredited, there's a whole lot of criteria you have to go through for it to be recognized as whether recognized university or not. What we are interested in, when we are doing our vetting, we now ask the relevant institution to put to us whether you are coming from a recognized university or whether it's not the most used university which you can accommodate. So those things can be dealt with. Thank you.
Yes.
So we're on page 5 also. No, of course, that one goes through. If it goes in the future, that will be done. As long as you've agreed in principle. Page 4, page 5.
Well, in page 4, you know, the other day, we discussed the issue of status when it comes to appointments. But the essence of that was not to allow the appointments to commence at the same time. To ensure institution.
We agree.
Yes, but what's not clear, I think the terms, it came up. You know, yes, a commissioner shall serve a full term of 5 years from the date of appointment, irrespective of the remaining terms of the commission. That's the end of it. There is nowhere that talks about giving reappointment. It's only a term of 5 years. So again,
that can be decided by proper.
Again, because we've had that for another term
Okay. That is on 4 also. Mr. Minister, take note of all of these issues.
Yes, Mr. Speaker, I beg to make some correction or some.
And AG, before, in fact, my attention has been drawn to by the clerk that it was even inserted on that.
Yes, certainly.
Thank you.
Certainly, Mr. Minister. So we proceed to page 5.
Mr. Speaker, before we proceed to page 5, with your leave, because of the modifications that have been made, section 32, subsection 4, we propose that some rewarding is done, especially relating to the age of 65 years. What I've gathered from honorable members, the intent is that if someone has attained the age of 65, then that person is not qualified to be appointed. Emphasis on the word appointed, Chief Electoral Commissioner. However, based on the submission that has been made and as approved by members of Parliament, if someone is already appointed for a term, and then in the course of that term, that person turns 65, he will still continue to hold that office until he or she finishes that term. Because the reading of it now, B, says a person shall not be qualified, B, to hold office as a member of the Electoral Commission, if he's a minister, deputy minister, member of parliament, or a public officer, or if he has attained the age of 65 years. So which means if under the current law, if you turn 65 while serving on the commission, you cease to qualify immediately. So the proposal would be for subsection 4 of section 32 to read, a person shall not be qualified for appointment as a member of the Electoral Commission, A, if he is not qualified to be elected as a member of parliament, and B, if he is a minister, deputy minister, a member of parliament, a public officer, or if he has attained the age of 65. So that way, that restriction, when you're 65, applies to appointment, not service. That would be the amendment, Mr. Speaker.
Yes, Mr. Chairman. So in that case, the issue of reappointment for such a person is null and void. If he has not
Are we set on that?
Yes, Mr. Speaker. Thank you.
Are we set?
Yes.
Mr. Minister.
Yes, Mr. Speaker. We have taken note of the correction, but we just wanted to provide that clarification.
Okay, sorry. Yes, so we move on to page 5 also.
Yes, Mr. Speaker.
Page 5.
I think in page 5, it's the subsection 2 was where we stopped in, which of course I strongly believe the leader
on page 5. No, we don't have 2 on page 5. 3.
No, B, I mean B, the B aspect.
Mr. Speaker, if I may.
It's the B aspect.
Oh, yeah, no.
Mr. Chairman.
Exactly.
Yes. Yes. So it should
be agreed to hold the instant law.
Yes.
Yes.
Thank you.
And under clause 3, I think we changed 2 to 1.
Yes.
We changed 2 to 1
instead of subsection 2.
I think under the proviso we did an amendment by the insertion of 61 or 61 or something like that. Am I clear on that?
Mr. Chairman, first, let us do an amendment for the 30%. We'll get a proper rendition, but we all accepted that we should have the 30% as enshrined in the Kiwi Act. So we should just import that one there.
Yes, that was what I agree. And I think there is something related to the executive. Not
yes, so we are here to ask the minister.
You have to guide us.
Yes. Yes.
Just a minute. Let me. You come. We need to have in the proper order. This one has to do with election. This one has to do with electoral laws here. The one that has to do with the executive, we are saying we place it 61. Yes. So it should be in the next page. It should be the other page. So for this, we sustain 30% as the Kiwi Act. Okay. So the thing I want the minister to clarify, is he going to carry the word shall as he proposed?
Yes, Speaker, Honourable Members, for
we still want to hear you on that.
For section 35, we will keep the word shall, and for section 61, it will be may.
Okay. Okay.
So the
That's on page 5.
Yeah, the submission is still in line. Is still in line with although the 30% party nominees for national and local government elections shall be remain.
Correct.
So the subsequent provisions in the public elections act, they remain the same. We don't touch that one at all. We don't import them.
Well, yes. The only thing is when we get to that, we will propose an amendment to section 58 of the Public Elections Act.
So we don't need to go far. So if we accept this one, we now go to Public Elections Act to do the subsequent amendment, because you have said, I also said also to sync in line with section 58 of the Public Elections Act. So here we maintain the word shall, Mr. Chairman, and we rely on the Public Elections Act to entrench, to make a clarification in section 58.
Correct.
Okay. All right.
So is that noted?
Yes, sir.
Then we move on to page 6. Yes.
I'm with the lawyer, the lawmaker. I just want some clarification.
Yes.
It's simple. One person representing. What is the difference between the two? When can the president appoint without being reference to any group? One person from.
Where is that?
Well, Chairman, I think he's talking about the search and nomination committee.
No, we are dealt with that. No, forget about the language, we are dealt with that.
Mr. Chairman,
yes.
There is no way I intend to do the job, sir.
Yes.
But again, there are certain areas where they agreed on, so you understand, no need to reopen them.
Yeah,
just like you're drawing our attention to the areas where we stop pins,
yes.
and those areas have been highlighted.
Yes,
Thank you, sir.
Mr. Chairman, sorry, sir. I beg to differ. Those questions are not. Those questions were agreed on principle. So what we need to do for the edification of the public, we have brought in all of those provisions we seemingly agree. But it has no force of law. Yes. So we have to state it.
Yes.
Especially they have worked out that we agree on those provisions, on principles. So what you are doing now, we are taking our time to go clause by clause, you stop keeping on them.
Yes.
So I'm now saying we have dealt with all of them that we proposed. 61.
Yes.
Making term limit for electoral commissioner. And what you are proposing, that we said, attend it because we say you cannot put it back. The qualification should be the same. And the year of 10 years and 5 years. I remember.
Yes.
We agree on those things.
It's all right.
So we have to go over it so that people can understand. We agree on them.
Of course. So page 5 to 6. Page 5 to 6.
Page 5 to 6. There is an area, the top part of that's section 4, the A and B. There we stock pins. The C and D that had to do with the census, we are fine with that. So it was the A and B aspect that we are going to look at, because talking about the aging as well, talking about moving the constituencies in the certification aspect, the A and B, those are the areas that we stock pin on.
So are we okay now with them? Because there's no much contention. You don't have much contention. So, are you okay with that leader of government business?
Yes.
So those provisions stay. Okay. Mr. Minister, the provisions stay, not so?
Yes. Yes.
Page 6, page 7. We deleted the independent candidate, also?
Correct.
Yes. And okay, so we are done with page 7. Page 8.
Well, it's clear that in page 8, E, that's where we have the issue of the threshold.
Yes, the threshold.
Yes.
But there is no more contention.
Well,
Mr. Speaker, I'd just like to clarify. I think we made clear in this that yes, in the bill, we have made a proposal for a threshold of a simple majority of total valid votes cast throughout Sierra Leone, and then to a minimum 20% of the total valid votes cast in at least 2/3 of the districts of Sierra Leone.
Well, I think you agreed.
Yes. Yes, I just wanted to make clear to everyone, including listening public, that we had agreed with the technical committee made up of the APC and government of Sierra Leone that the amended bill on the floor of this House is to read that a person shall not be declared elected President of Sierra Leone unless at the presidential election he obtains a vote of 50% plus 1 of the total valid vote cast.
50% plus 1?
Yes.
Okay.
Of the total valid votes cast.
The total valid votes cast. Okay.
So, and that removes the threshold and the simple majority.
So 50 plus 1?
Plus 1, yes, 50% plus 1.
Yeah, Mr. Chairman. Mr. Chairman, this is in line with the tripartite recommendation.
Hold on.
Mr. Chairman, so the one we have in B, we have the tripartite, and this is in line with the white paper in June 2017. More than 50%. Everything is in line. So what we are saying now, because tripartite is so recent and it's in conformity with most of the provisions, so we forget about the threshold, district threshold, yes, and stick to 50 plus 1. Yes, now let me be a little case for the public. If you go to section 42E of the Constitution, the first phase, the proposal we have, what is the extant provision, is 55%. And if there is a runoff, F of that provision, section 42, subsection 2F, saying it's going to be simple majority. In 14 days, because you do elections in 14 days with simple majority. So there is not really much difference, I say. But this one is more entrenched, it's more classified in terms of reaching out to other political parties. So some of us will receive another provision from PPRC, from APA, that there is a situation where you will not get the 50 plus 1. What happens? So we are saying for national inclusivity, because they have argued on that
of course, if the law says 50 plus 1, if you can't get 50 plus 1, then you do runoff. Then there's runoff.
So in a case where,
and in runoff, the one who stopped the highest wins.
The simple majority. So there is a proposal also that instead of going around doing runoff, what about making the coalition with other parties that will give it 50 plus 1? Yes, so you not do runoff. That was the proposal from the APA, from all political parties. That was the proposal. So if the AG, so we need to discuss this. Mr. Chairman,
yes,
there's the proposal from APA.
AG.
So if this house says,
is it not 50 plus 1, and in the event no political party scores 50 plus 1?
That is the case.
Yes.
Yeah, Mr. Chairman, repealing this particular section by bringing in the tripartite recommendation, fair enough. We realize that tripartite recommendation, both parties were there, and the presence also of international community. It will be very fair enough if we import tripartite recommendation to this bill now. And by repealing this today, I think we will join the rest of the world. The entire ECOWAS, as a member of ECOWAS Parliament, I realize that right in the Supplementary Act, Article 40, subsection 2, is saying countries should endeavor to have uniform laws. I think it is only Sierra Leone that is still going with 55% to make a president. But all of the ECOWAS countries do your research, they are all 50.1 or simple majority. In fact, to the extent of even AU, 54 countries comprising the AU, all of those AU countries, they practice 50.1 or simple majority. So repealing this age-long draconic law today will help Sierra Leone to join the rest of the world. I so submit.
Yes, proceed.
Yeah, Mr. Chairman, I also just want to clarify that with this proposal and of course adopting what the federal government said. So this proposal, just to be clear, that yes, the 50+1 threshold, which will read, no person shall be elected as president of Sierra Leone unless at the presidential election he has polled a total of 50 plus a minimum, not less than 50% plus 1 of the valid votes in his favor. And so the threshold which we see under 2 of that clause will go away completely.
Of course, we have stated that.
Okay, good. And
well, I think what the leader wants to know is in the event nobody scores 50+1.
The government
has to be done.
The government's position on this for now is in the default of a candidate being duly elected under the provision that I just read, the 2 candidates with the highest number of numbers of votes shall go forward to run off for the second election.
That's more realistic.
All those in favor say aye. Aye. Those against say nay. Proceed. Page 9.
Mr. Chairman, just
page 9
for neatness of proceedings, it's clear that this aspect of the bottom part of page 8, way to the top part of page 11, we agreed to take all of that to the Public Elections Act.
That is very correct, Mr. Speaker.
Yes, all of that. Yes, we take all of that. So that should be the bottom part of page 8, page 9, page 10 also.
In fact, to the top part of page 11, just above clause 8.
Yes, we agreed. Okay, thank you. Now, the remaining part of page 11. Yes, under this one, we said to which the state is a party. But we decided to remove that to say any criminal.
Yes, to delete that aspect to which the state is a party.
No, not the state. We removed that aspect.
Yes, that's what I'm saying.
And we made it general.
Yes, sir.
Mr. Minister, take note of that. That's for page 11.
Chairman, can we get a clear text of this one that you are saying?
We said in 43, in the event that the presidential candidate is standing trial on the criminal charge, it deletes to which the state is a party. Delete that one, to which the state is a party. On the criminal charge 1 year prior to the election. So we just delete that as well. So it becomes general, whether private or state prosecution.
So we also said trial is suspended.
Yes.
After.
Yes, after 1 year. That's for page 11. Page 12.
Mr. Chairman.
Yes.
Yes, just a clarification. So this goes for purely presidential candidate, not their running mates.
Of course. Yes, page 12.
Page 12, remember the top part of page 12, which has to be, yes, was
Yes, this one was deleted. Delete.
Yes, the top part, yes. And also,
we deleted 10.
In fact, 10 was the transitional provision, and we deleted 10 to the top part of page 13.
And we deleted president or
yes, because that provision has to do with the vice president, so the word president was redundant.
Yes. Then under 12E, we deleted expulsion.
Expulsion was replaced with his removal.
So under clause 13?
Well, 13 at some point had a contention for some reasons. Again, we can go back again to the AG. We stock opinion on clause 13.
On 13. AG. Yes. We have dealt with that. Yeah, we have dealt with that. Yes, AG. That's it.
Sorry, Mr. Speaker, I left that side. Can you please go over that? Can you please go over that?
Well, I was saying
there was contention with proportional representation.
Yes, that was clause 13. That was the only area where we stock opinion. Yes. The other areas had to do with removal of the vice president, but the president was inserted and we deleted president.
Yes, we deleted.
Yeah, yes,
please. No, we are on clause 13.
So that, yes, I'm just taking it through.
Yes, Speaker. Yes, we keep the proposal to amend Section 74 of the Constitution to read B. Such number of members of Parliament as Parliament may prescribe who, subject to this Constitution, shall be elected through a system of proportional representation. And then we have included an additional link to say, with a detailed mode, method of nomination and conduct of such elections prescribed by or under an act of Parliament. And Mr. Speaker, with your leave, I'd like to just provide some context on that.
Yes, please.
That additional link.
The addition should be done in a separate statute.
Yeah, that is what.
Yes,
that is what.
Well, of course.
No. So
then what do you need to explain now?
You don't need to. You are going to bring us into.
What do you need to explain?
So I'm just trying to provide. So of course we want to keep the name of that. The detailed mode and method of nomination be prescribed in a separate legislation. I think we're on the same page on that. I just wanted to say, if required, I'm happy to provide context on why we recommend that. But if members of Parliament, already have the context that such prescription will be made in a separate law, and we will have a conversation on such proposals. We are happy to leave the conversation on at that.
Yes. So. On page 14, page 15.
Mr. Chairman, on page 14.
Yes.
We stock a smaller bill. Well, in a sense that we had to agree on the safeguards.
Yes, the safeguards. Have you done the rendition for the safeguards?
Well, to some point.
Yes.
Because
read them out.
One. With regards, we have to agree on something because it will affect changes in some other areas which we have to look at. That's what Mr. Thompson said. At some point, we'll have to revisit 41. We'll have to revisit 54 because 41, the qualification for president, 54, the qualification for president. Also on that particular aspect, then 56 to 60 ministers, then 75 to 77 members of parliament. And then, to some extent, even if possible, add So, now, we're going to settle on something because it's going to be clear that certain positions, which were already clear on that day, the president, the vice president, the Speaker, the Chief Justice, those areas are prevented from that particular change. So let me read something as part of the safeguard. A person who is a dual citizen shall have been ordinarily resident in Sierra Leone for a period of not less than 24 months, immediately preceding the date of nomination or appointment. Other safeguards, we talk about NACIT. And then also on that day, I also raised the issue of disclosure of all foreign citizenship. It's also very important because if we consider you here as a dual citizen, we must know the other nationality which you held again. Of course, disclose any foreign public office.
I hope Mr. AG, you are taking note. And Mr. Thompson is here also. Take note of all of those issues.
Yes, Mr. Speaker, we did take note of all of those, and I think we are on the same page.
Yeah, do a proper rendition to reflect that.
Mr. Chairman.
Yes.
I still have with you that he made a lot of proposals that we are making difficulties. So, the chairman. Yeah. So I was thinking I should have given us a new edition, putting in place like layer proposed president, vice president.
She actually did.
You do different category. We'll take another category. It has to do with other people. We are proposing
you can use a legalese instead of having those. You can use a legalese to reflect the position in all of those sections you refer to. Understanding what is in that. So
because
like that.
Chairman, we have to be very careful in dealing with it. Don't forget that there are other legislation, and this one we have to maintain the provision this year. It has to be voluntary, not to naturalize. So we have to maintain that clause to justify why we cannot be the chief executive officer, why we cannot be the ordinary belief. That's the key. No, it's just the proposal I'm making, not that I'm making a submission. I'm still in line with what you proposed. Yes. But I want us to be clear on the text he provided to us. If you read the text, it's very clear voluntarily or on any declaration of allegiance. That is what we are doing. And that is what is in mind, the spirit of why we are changing to the 6-1. So if we categorize them as we started, for the other categories, so being in line with other existing legislations, it can be fine. I don't want us to go too deep. Where you can be at the end of the day, if you're talking about to be the dual citizenship of voluntary, you want to be ministers, you have to go and make another amendment in 56. You know that very well, Mr. Minister. Oh yes, I'm drawing attention. You have to make another amendment in 56. You have to have the rendition, and we go back for 56. Because you cannot be a member of parliament, you're not a member of parliament, you're not a minister. Yeah. So if you're making exceptions, we have to go for 56. If we want our brothers in the diaspora to be part of us, we have to be there. We have to be careful. We need the debate, both sides of the aisle.
What I mean, we have agreed in principle on all of these issues. But it is now for the draftsman to go prepare a proper rendition.
Yeah, but I have it clearly talking about what he told us. Those ones was too much. The list was like on any. And it was making like too naive for us to keep to those things in the constitution. But I'm just saying, which are with me in principle, that let us go back and look at them. We all agree, because this is not about us. This is about our own family members who are what has happened because as a son of our family. So what we said that we now look at the edition carefully with other legislation, so we cannot mix them up. So that when we come, we now put them properly. It is going to the constitution. So that is it. Okay, thank you.
Yes, all those in favor say aye. Those against say nay. The ayes have it. Let the rendition be done.
A clarification, Mr. Chairman.
Yes, the rendition is going to be done. But I just want again to make it clear that I mentioned the provisions. Any other school falls shall come under the solution because I listed all. So let's really be clear on that particular side.
So what we have agreed when you do the rendition, make sure I see it.
Yes, again,
do the rendition and bring it, let me see.
Why I'm going over this again, I mentioned the position. The president, the vice president, the Speaker, and the Chief Justice. The day I made the submission, there were some other positions. But again, the House never accepted it for some of those. But we had to bring, because I raised a point about the Inspector General of Police, the Chief of Defense Staff, and many more. So let's be clear that that day I made the submission. So we have to provide safeguards where I talk about the 24 months.
This is a position that was accepted for petitions. It was accepted.
And in fact, I also, the honorable leader is there, I read or I highlighted the provisions that we will revisit at some point, together with the aspects of course 54, 41, and then 56 to 60.
Mr. Clark, take note of that.
Sorry, Mr. Yes. I think, Mr. Speaker, honorable members, I think for government in the submission last week, unfortunately, I left the piece of paper where we had proposed the rendition for Section 76. Look through my file; it's not here. But our proposal was to add a proviso under Section 76 to read as if a person, something actually, and I had worked on it, just don't have it. But we're basically saying a person who is a Sierra Leonean by birth, but holds the citizenship of another country. We put it in the context of the negative. They shall not be qualified to run for election as member of parliament unless that person has paid local taxes to the community for 5 years preceding their candidacy for such an election, and that person has been physically resident in Sierra Leone for a period of less than 24 months. And then we provided additional language to say that such a person shall not be qualified to hold office of president, vice president, speaker of parliament, and chief justice, because these are all positions in line with the presidency. Any of these persons can act as president at any time. But for the other positions that were suggested, I think, Mr. Speaker, honorable members, I laid out with concrete examples why we will design ourselves in ways that will affect us in the future if we attempt to extend such a restriction to other positions, including Chief of Defense Staff, Inspector General of Police, noting, as I said, that we have had foreign nationals holding offices before, or that the Sierra Leone national has served as Chief Justice in another country before, although in that country their constitution doesn't provide for being in line to act as president. And then, of course, other examples about the governor of the Bank of Sierra Leone provided an example of the current Prime Minister of Ghana, who was the governor of the Bank of England, etc., etc. So notice that Sierra Leoneans by birth who will hold citizenship of other countries, but might have significant contributions to make to various sectors, and at a particular time when they might be the best fit to serve in these positions. Our submission, Mr. Speaker, honorable members, that we should not restrict ourselves too much. But for government, we are very happy keeping these restrictions to the positions that we have highlighted, which is one, such a person will not hold the office of President, Vice President, Speaker, and Chief Justice. That is the submission, Mr. Speaker.
other members.
Yes,
we should also bear in mind that we amended section 7 to allow all of us to serve as speaker, and there is no way we are going to make a law debarring members of parliament to become speakers. Because, for instance, Mr. Minister,
not members of parliament, who are citizens.
No, the fact that the person is qualified to be a member of parliament, they should be qualified to have.
It's like saying the dual citizen can become the president.
It's like, why are we allowed?
Do you accept that?
If they are members of parliament.
Oh no, do you accept a dual citizen to become a president?
No, he is not a dual citizen because he's a member of parliament. We are also now stating that members of parliament, we should have two categories of members of parliament. We have people who are dual citizens and people who are not. And it's the section 78 of the Constitution. It said that members to be qualified speaker. Yes. So if you are a member of parliament, you should be qualified to be elected as a speaker. Let
me understand something. So you are against dual citizens?
No, we are not. I am against the decision that members of parliament who are dual citizens should not serve as speaker. If they are qualified to be members of parliament, they should be qualified to be elected as speaker. They should be qualified.
Mr. Chairman, the only reason why the only reason why they do not want them to become speaker is because he cannot be president. He cannot be president. And the speaker acts as president. That's the only reason. The speaker normally acts as president. The chief justice normally acts as president. As a matter of fact, I've acted as president over several times. You cannot have a dual citizen acting as president.
Then we can equally say let us not have them in parliament. But we can start that would be defeative of section 78 as amended, sir. It will be defeative of section 78 as amended. Because section 78 states, if you are coming from outside parliament, you should have served parliament for 2 terms. And if you are coming from within parliament, you should have served parliament for 1 term. If we now state that as a member of parliament, you are not qualified to be elected as speaker, because you have a dual citizen. How did you come to parliament? Your presence as a member of parliament qualifies you to be elected as speaker.
Mr. Chairman, everywhere in the world, for you to be president, you have the office.
Yes.
It's a serious office.
You have to be.
It's a serious office.
The presidency
for you
is
to be nominated as speaker, that's what we militate against. That's why I must keep in mind the voluntary naturalization that you have voluntarily naturalized as you are carrying dual citizenship. So we can not much have to make critical decision on behalf of the state, and we are acting as president in the 2 interests. So we don't even want you because we have placed a bar. We are president and vice president. You can't be president. That's the people provision. President and vice president. So we don't even want you to act as president in this capacity. That's why we are putting Chief Justice and the Speaker of Parliament, because you have acted. Yes.
I don't think the people you are fighting for.
No, we are not fighting.
I don't think they are fussy about that.
No, we are
because the point, what I'm saying, the only reason why the Speaker, the Chief Justice, Vice President, those positions are being accepted is because you cannot be a dual citizen and become the president of the nation. It's a matter of allegiance. It's a matter of allegiance. It's a matter of allegiance. You cannot be a dual citizen and become the president of the nation. In fact, it's almost all over. It's almost all over. So if we have a unique situation in Sierra Leone where we want to bring our brothers in, then we can still bring them in with certain safeguards so that we don't compromise the security of the state with certain safeguards. That's the only reason why.
Mr. Chairman, if we let us make or consider that discussion, be able to start it this time. Mr. Chairman, the position of a minister of a state is a very sensitive position, a very serious position. If we have allowed bosses who have dual citizens to serve in that position as ministers, to serve positions as members of parliament, leaders of government business, how can we now say we don't allow them to serve as speakers? Don't forget, ministers negotiate contracts on our behalf as a state. They come into agreement on our behalf as a state. So if we are going to allow them to serve, it is like not to wait to Section 77 and amend the law. It is like not to wait to Section 77 and amend the law. Because they will take first to be qualified to be speaker, you should be a member of parliament. How can you have a member of parliament and you not begin to draw the line between, oh, you are just MP, you know, to the JC MP, you not qualified? If you are qualified to be a member of parliament, you should be qualified to sit in that.
Yes, Chairman. You are not saying, you see, you cannot, it's okay. Yes. Where have you seen a person who are voluntarily giving his administration to be president? Where have you seen that in the world? The best practice. There's no need for contradiction. Nowhere in the world cannot be. You know, we don't make ourselves funny. We are making it presentation funny. Are you saying we are American citizens or you are a citizen of Ghana? You want to be citizen of Sierra Leone? You are acting as a president. You are acting as a president. So, if there is a submission, we continue to put restrictions on the 6. This is an exception. The other claims, you cannot even be in America. You cannot even be a member of the police force. When you are doing citizenship, you cannot even be a member of the police force. So, there are bars. This is a big bar that you cannot be president and vice president. The reason why I bring the chief justice and the speaker because they are acting in that capacity. Let me be realistic. These are exceptional clauses. You have ruled. You have an hour ago exceptional clauses. We are not making it 76 to be accepted. Yes, you can be a member of parliament, but it's only the domain of parliament and the president.
Yes, you cannot be speaker. If you want to be speaker, you go and
exactly.
You don't need food. You know, if you want to become speaker, yes. Everybody relinquish. You don't need food.
Mr. Chairman, I think I agree with the minister and the leader of the opposition. There should be a bar. You can come to parliament if they have participation, but you cannot buy to become a speaker of the parliament. It is a law I'm still on my legs. Mr. Chairman. As long as there is a law, yes, you can come to parliament, but you cannot buy to be speaker. Or even the president at that time will not to be
you can go and relinquish.
Exactly. That's why the second thing, Mr. Speaker, let us not talk about having a local tax for 5 years. As I'm talking to you now, my daughter is in America. I have local tax for her for the next 3 years. So that's it will not work. It's not work, Mr. Speaker. Thank you. You can get local tax even outside the country as long as they belong in that particular kingdom. So that is very flexible. But I agree with you and the leader and the speaker. When you want to be speaker of this parliament, because when you're a speaker, the speaker they have acted as president more than twice. We cannot have a foreigner.
7 times.
Thank you, 7 times.
I have ruled you 7 times.
We cannot have somebody who has become a speaker of parliament. When you want to be, you want to apply for speakership, you go and denounce your citizenship. I do it, Mr.
So, Honorable Bashir Siliki, I don't think that is
Mr. Chairman.
Let us
amend section 7.
Actually, you can be qualified to become speaker, but you have to, even if you are a God citizen, before you become speaker, you have to go and relinquish.
What does it say?
But when you occupy that position, you act as president.
But Mr. Speaker, honorable members, I was a member of parliament when we amended section 7. And section 7 reads, Mr. Speaker, it reads that if you are coming from outside parliament, you should have served parliament for 2 terms of 10 years. So if you are coming from the parliament, you should have served parliament for 1 term of 5 years. And a member of parliament who have served parliament for 1 term, or is coming from outside who have served for 2 terms, it is better we say let us go back and make section 98, 78 that was amended.
We cannot amend. We don't have
Mr. Chairman, Mr. Chairman, we can put that on the exception clause. We can put that on the exception clause.
Okay,
Mr. Chairman, before the minister. Mr. Chairman,
Mr. Speaker,
let me have minister.
Mr. Speaker, honorable members, so the restriction, if you hold...
Sergeant Adams, I told you to close the door, not so? That's a simple directive. Close the door. Only members of parliament are allowed to go out and come in. Carry on.
So the restriction, just to be clear, if you are a Sierra Leone member but hold the citizenship of another country, the restriction is actually for the presidency. So, which means you are getting the right to participate in the politics of the country, but noting that you have a restriction to occupy the presidency. No, please. You have a restriction to act, to occupy the presidency. If you want to occupy the position of president, then you relinquish that additional nationality. Now, the reason why these other positions are coming into play, it's simply because these persons could act as president at any time. And so it is to ensure that if someone who is a Sierra Leone member but holds the citizenship of another country gets into the political space, we ensure that that person does not act in the position of president. That is the only reason why Chief Justice and Speaker are coming in. Now, we do not need to amend Section 78, because while Section 78 there are very clearly persons who could be elected as Speaker, the restriction in 76 will apply if that individual wants to become Speaker. That is what this will mean. So we don't need to amend 76 because there is already a restriction in 76 which will apply to President, which will apply to Vice President, which will apply to Speaker, and which will apply to Chief Justice. That is what this will mean. Thank you, Mr. Speaker.
That's for page. Please, honorable members, I would rather want the leader of government business and the chairman legislative committee, or the leaders to take the lead, because you debated, all of you debated.
They have a caucus with us. We still have differences.
Because
we still have minor differences, Mr. Chairman.
I don't want to open this thing to a debate.
It's not enough one.
Yes, sir.
We are finding a way out.
Mr. Chairman. Yes, sir.
We are finding a way out.
Yes, sir.
What do you want to say on this matter?
No, Mr. Chairman. Mr. Chairman.
Yes.
A different one.
Yes.
On this particular.
It's not different.
No, Mr. Chairman.
It's not different.
I have the leader of government business of the minister. The last time, one of the safeguards was about the contribution for the social security for the period of.
Of course.
Yes, but when the new edition was pronounced, I immediately had that.
No, that was to be included.
We are coming to that.
Yeah.
We'll come to that.
So it's still part of the.
Yes.
Of course.
Okay.
Yes, Honorable Bokari. 1 minute.
I think we are gradually getting entangled in this whole issue. So I am proposing that the best way to get ourselves out of where we are now is that maybe we maintain the extant law.
No.
If I accept it, how could you discriminate against someone who has been an MP maybe for 2 terms and yes, and they are listening to the position of the current speaker?
There is no discrimination. There is only conditions. There is no discrimination. You are free to become, but you have to respect the law. No more debate on this matter. No more debate. It's confusion.
Mr. Speaker, Mr. Chairman, as you are not implementing for SO42. Let's start on SO42.
Yes. Honorable leader.
On that note, Mr. Chairman, is party. I therefore move that we suspend SO5 to citizens of the House to continue.
Any second? All those in favor say aye. All those in favor say aye. Aye. Those against say nay. The ayes have it. Yes, leader. On this matter.
On the 76th, you see, I've started seeing the girl trying to confusion, trying to say we cannot amend. Genuinely, we want to amend 76. I mean, those in the diaspora, I don't think they intent. It's really for them to come and be president. It's really to give them space to really participate in our democratic process and give some leverage. You know, I've not seen anywhere where you have clearly, voluntarily declare yourself to be a citizen in another country. Everybody knows about it. And you are coming to be a president. Yes. No, let me after a president. Yes. So we need to be careful. It's a serious business. The AG has advised us. He's a legal advisor. No matter what you say. He said these are exceptions. He brought in his amendment. He said these are exceptions. It cannot be. So we have to play some seriousness in the legislation. That does that. So I appeal to my colleagues, even a deputy leader, that because we are not giving him. Initially, we did not access him to 6. We have to start somewhere. And even when I reminded him about 56, he said he will now amend it. I was when you do something 76, we take care of 56, not Mr. Minister.
Correct.
So we are going to look at all these provisions, so there will be a taboo with the extra law.
Yes, actually, we proceed. That's for page 14, page 15.
Yes.
Is it still on this point?
No. This point is still continuing.
Honorable Bashir, still on this point?
I still believe we should amend section 78. I might not win, but let me just state my position. And it should be recorded.
Yes.
Section 78 was amended by all of us. This parliament, it was amended. I know, Mr. Speaker, Mr. Chairman, honorable members, when we came to this parliament in 2012, we had a lot of persons coming from the diaspora who were members of parliament. And after today, Mr. Speaker, nobody will question who has dual citizen or not. All of us will have to contest elections. Then people will have to contest elections and they will come and nobody will have to declare. Nobody will have to declare that, oh, SO to me have to see nominal ones. We are all saying
which part of section 78 you want amended?
That is the qualification of the member of Speaker.
Mr. Speaker,
it is amended. It is not,
read section 78.
Section 78 reads.
Read section 78.
Section 78 reads. No, it is not here. You cannot, it's amended here. It's amended, the amended version.
Point of order, sir. Point of order. Yes. 34. The side note has to do with the High Court, blah, 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 to say, Mr. Chairman, Mr. Chairman, our colleague needs to understand. Our colleague needs to understand. Yeah? So, no, Mr. Chairman, my colleague needs to understand. You know, you just want to, when we push, somebody said, the panel just maintain a instant position. The spirit is to have our fellow citizens abroad to participate in the electoral process. But you cannot say I'm going to be an American, to be Australian, you want to be president, not to be Speaker of Parliament. That should be a bar.
So that you are almost always in America.
You're right. You're right. Because you're a U.S. citizen. You're right. So, colleagues, the minister has proposed to us. He has made the position very clear that let us accept the amendment that proposed with an exception. Let us move forward. Our colleagues in the diaspora, I think what they propose, what I have from there, I have a text from there. That's maybe if you are here 5 years, nothing. We got all those things from there. They are never mentioned that you want to be president. Yes. If you want to be president, recuse yourself.
Yeah, of course.
Just apply that, no, my identity is gone. I'm now purely extraordinary. I don't have to anymore. That's what I'm saying. But let the nation, beyond these functions of Sierra Leone, let us see us as a serious legislator that we are putting a power on presidency.
Of course.
This position when you're in here, nobody can stop you.
Yeah, let the proper rendition be done, eh?
Certainly.
Certainly. Let the proper rendition be done to that effect.
Certainly.
That's on page 14, page 15. Page 15.
Page 15. Page 15. Yeah. Mr. Speaker, actually I'm pleading, and I'm sure our minister will agree with me. I'm talking about where members are obliged to resign from public office at least 6 months before the date of election. Let me land, please. No, we did not. Am I protected? She's protected. Am I protected? Yes. Okay. Hear me, Mr. Speaker. Mr. Speaker, we have our, government workers, like the police, like the military, like the nurses, who intend actually to come to Parliament one day. And their salaries will not allow them to resign 12 months before.
Page 16.
Page 16, Mr. Chairman.
Page 16, Mr. Chairman.
Chairman,
16.
I'm still on page 15.
Yeah, what is that?
Let's just be clear here, because again, some parts wherein they mentioned the Anti-Corruption Act of 2008, we already.
Yes, proceed.
Yes, the page 15, just a reminder that we took from the mid to the bottom part of it to the Public Elections Act.
Yes, Honorable Conte.
Yes, if you can recall, starting from C, the AG made that clarification, what you have in paragraph H, it was a mistake, it becomes paragraph E. So, again, Mr. AG. Correct. In page 15, just for the records. Remember we had H, but again you came up and said it was paragraph E.
Yes. Yes, take note of that, AG.
Yes, Mr. Speaker, that is amended.
Yes, and the bottom aspect of it was moved to we agreed to move it to the Public Elections Act.
Correct.
That's for page 15 also?
Yes, 2.
Is that noted?
That's noted.
That was...
We dealt with all of these provisions.
Yes, no, it's the confirmation. You understand?
Okay, yes, take note of that.
Like you said, we're going page by page, just the confirmation.
Yes, Mr. Minister, take note of that.
I have.
Now page 16.
And page
Section 15.
Yes.
Just a clarification for the minister.
Yes.
We are talking about 2 plus 2. You talk about E. We're talking about election-related offences. Somebody been debarred for 12 months, a bit convicted for 12 months, and should not participate.
Yes.
We can the AG, because election-related offences is for me. It's so vague. We don't have no qualification for that. Election, it can be minor, it can be major, it can be. So when you talk about
minor, whether major, as long as you have been convicted,
yeah,
then you are not qualified.
Mr. Chairman, my argument here is we talk about the dropping of charges or cases against presidential candidates.
Yes.
For political reasons or non-political reasons, we have qualified that,
yes,
both civil and political.
Yes.
Now, you now come to election-related offences,
yes,
and we are all politicians. Somebody somewhere will just look at you at one point, then say you committed XYZ because of
Mr. Let me talk to you on this. You see, when they make laws, these minute details about life you cannot put into law. If you want to take care of everything in a law, you will never end.
Mr. Chairman, these are my needs.
It's a minute thing.
Mr. Speaker,
You think somebody can just come, no, he did this, and they take you to court and they convict you?
Mr. Speaker, if I may.
Put up a defense. You put up a defense.
Mr. Speaker,
Mr. Speaker, if I may.
Yes,
when we put disqualifiers in laws, it's only when they are established such. Let us say for criminal conduct, if someone is disqualified for criminal conduct, it's only when that is established by the court. It's not when somebody points to you that you've done this. It's only when you have been convicted. Exactly. And the point is, we have also included language to read that these are offences for which someone will serve jail time. These are not offences for which the sentences can be even substituted by fines.
Yes.
Again, if I may add, Mr. Speaker, honorable members, I started corrected. Whilst I argued strongly that this provision is in the Constitution,
I think the leader of government business have moved that these proposals be moved to the Public Elections Act. So I think where we ended with this was the removal of two from this bill. In any case, Mr. Speaker, I also want to add, I think I need to provide clarity on this issue of elections-related offences because I think the Deputy Leader of the Opposition raised the same issue. Actually, in the Constitution right now, when we see the extant law, yes, election-related offences are there. Yes. They're there. If you are convicted of fraud, dishonesty, or election-related offences, you'll be disqualified. So basically, we're just expanding the scope. Right? We were just expanding the scope, but I think this House has resolved that this expansion be moved into the Public Elections Act.
Okay. Now, yes.
Sorry, I understand exactly what the bill says, but if you say elections related offences, let me cite an example. I was petitioned in 2018 election. The APC won the 2018 elections. I was going to remove. Why? One of the grounds of the petition was there was a fight at the police center, and I was there. And to them, it was an election-related offense that should have taken me out of this parliament because I was there and I was a candidate. So it is too vague. Because, and you are saying, Mr. Speaker, that even how to spoil the offenses. When your opponent wants to go against you, and you are a strong force, they can bring allegations that and they can win in the court. We all know the court system. So I don't think of sorry, I will draw that one. But there was a matter that was raised. When I was fighting and I was part of it. How can I be part of it? It is fair. So let us narrow it and decide it. So nobody will be
what across the Public Elections Act offences are listed.
Yes.
They are not big.
Yes.
Election-related offences are specific. If they are not outlined in law, you cannot be charged or prosecuted for them.
In fact, I think this one is part of those laws.
Exactly. But also, Mr. Speaker,
you can raise that in the Elections Act.
Yeah, you can raise that, when you look at the sections that outline offences that are termed as election-related offences. But also, Mr. Speaker, I think we need to establish one thing. Again, I say, when we last discussed these proposals, my understanding was that we settled on they move into the detail to move them to the Public Elections Act. Evidence the position of this House that these proposals will be discussed in the context of the bill, and let's discuss them. But if it's the position of this House that we should move to the Public Elections Act, then I don't think we should be discussing them now.
So, Chairman, the reason why because he made a very salient point, which I like, but there are reasons for so much trials not to really state in the Constitution because we have to make a conviction. The issue here is conviction. When you are convicted, you don't contest the election. That's clear. But the reason that I brought to the fore why I think we should take the constitution because I argue on behalf of rape and sexual penetration. And I said, that law says people are supposed to do something. There is an administration that's supposed to do as a nation we have done. The administration has about forensic testing. And by the time you want to go and charge terrorism, if you are charging terrorism, it's not accessible. So we said, we need in the Public Elections Act, play more role. By the time you can broaden the definition, election violence, for in fact, the election violence or election offenses, they are well dealt with the Public Elections Act. whether you are at the scene, you are not there as candidate. Those things are very, very clear. So for me, we should move them. And I think the age has agreed with me on this serious issue. But what should maintain, and that's what's in the Constitution, when you are convicted, now we are not saying because we have to deal with such offences, let the new ones come in here, the rape and sexual penetration, let it be treated in the Public Elections Act. So we can exhaust it extensively before taking decision in terms of that's our offences that in fact things that are bound not to contest. So in the most serious you accepted. So that's what we are saying. So addendum to that, we can again review for every election the dynamics. We can review the election offences and we broaden it up to see what are the election offences coming up as new ones. That's why we are still asking that under the Constitutional Amendment of the Public Elections Act.
Page 16. Are we okay with page 16? 16. Page 16. Yes, Honorable Mustafa.
Still, 16 is a follow-up from 15. 3. A disqualification under subsection 2 shall end. A. 5 years after the sentence has been completed or the person is pardoned.
We deleted all of those. We deleted all of those. In fact, the whole of page 16 and page 17.
Why not 10? Yeah.
Okay, we maintain clause 17 downwards.
Yes.
We only maintain, in fact, let's just debate on 17 and 18. Then we are done.
No, Mr. Speaker,
before that.
Yeah. Yes, Mr. Minister.
Yes, so if I may, with your leave, Mr. Speaker, still on criminal conduct. First, let's note that certain criminal conducts are listed in the Constitution, which will disqualify someone from serving as a member of Parliament. 76(1) D says if he has been convicted and sentenced for an offense which involves fraud or dishonesty. And then E, which we have proposed to delete now, says if he is under a sentence of death imposed on him by any court, because we have I'm reading from the Constitution. Because we've abolished the death penalty. And then section 76 of the Constitution, subsection 2, says a person shall not be qualified for election to Parliament if he is convicted by any court of any offence connected with the election of members of Parliament. Mr. Speaker, I just want to add that we note the specificity on D, fraud or dishonesty. So now we can say corruption-related offences. But I just really want to go back to cabinet. The seriousness that cabinet attaches to persons who have been convicted for offences like treason, murder or manslaughter, rape or sexual penetration were particularly important to His Excellency and the rest of the members of Cabinet. So my question will be that yes, there are broader offences, especially relating to, say, the provision saying if someone has committed an offence for which they've served a sentence of 12 months, minimum 12 months, then they will be disqualified. Is it possible to say yes, the proposal on 12-month sentence does not come into Constitution, but because the Constitution, the extant law, is specific on fraud and dishonesty, and the seriousness that we attach to rape and sexual penetration, murder or manslaughter and treason, is it possible to keep these three categories of offences within the Constitution? Those three categories.
Mr. Chairman, yes, I think he tried to draw attention to 76. Now, if you look at 76, it's really limited in terms of offences. You don't mind, I can read. I really move and take a picture. You are crossing before me.
Yes, Peter.
76, Mr. Chairman. Let me read so that we can. First, we can talk about completion. I've accepted the proposal for completion. But how do we deal with cases of sexual penetration? How do you dishonest? The level of dishonesty is not let me read 76E. D, let's start with D. We said if he has been convicted and sentenced for an offense which involves fraud or dishonesty. So for us, we can hold this one as an extant law, but in the public elections, we know this what are the things that talk about dishonesty. And fraud, what do we consider fraud and dishonesty? We put it in the public elections as clearly. That is one. And other offenses, what I've stated again, we can roll it up. Other issues that related to sexual penetration, even terrorism. The one that we need to remove is the death penalty. We don't need it anymore. Now, because it said we have amended the penalty. So we can really now deal with conviction. Because it said if he is under a sentence of death, we cannot have a sentence again. So we want to be consistent with what you have done. We have repealed the death penalty from the Constitution. Imposed on him or by any court. So we need not to have this one. The chairman, are you with me? The death penalty should not stand.
The only thing is that I think you are all missing the point. This is something we deleted.
So he brought in fraud.
It's already in the public elections, that is in the Constitution. I don't know why you
he's making reference to D76 D, but fraud involves fraud.
What is the read of this one? Yeah, of course.
The E is gone.
Yes, everything is gone.
No, but he's gone. No, D is all gone. What he saying, he wants us to maintain this as a system.
That one is already in the Constitution.
Yes. So when we come to public elections now, we itemize them. That's why it's
we'll come to that.
So that's why it's
well, we don't discuss this. We are taking this to the Public Elections Act. So we don't need to belabor the point of this.
What do you need, sir?
We should only deal with clause 17 and 18 now. 17 and 18.
But, Mr. Chairman, even 17 and 18, we had a lengthy debate on that, and I don't think we had issues anymore.
Yes.
It was about the issue of professionalism of the police and the military, and we were very clear about the points of conduct.
Of course.
So, again, but I think here in 17, 18, the clause I was looking out for, the provision that you can insert under the Electoral Commission here is here, act in a partisan manner. I think they put it here for the police and the military.
Yes.
So we can get that again under the Chief Electoral Commissioner,
yes.
act in a partisan manner.
Okay.
Thank you very much.
Mr. Speaker, I wanted to give you feedback.
Mr. Speaker, I've conferred with the leader of government business and those proposals were expunged and moved to Public Elections Act. We'll agree that together. Thank you.
Yes, thank you. So we are done. Mr. Minister, can you now move?
Mr. Speaker, Mr. Chairman, honorable members, I move that Part 1, clauses 1 to 18 stand part of the bill as amended.
Honorable members, the question is that Part 1, clauses 1 to 18 stand part of the bill as amended. All those in favor say aye. Aye. Those against say nay. The ayes are.
Part 1, clauses 1 to 18 form part of the bill as amended. The House is used.
Yes, Mr. Minister, report.
Mr. Speaker.
Hold on. Leader of government business, please come. Honorable Mara, please, Mara, please come. Honorable Mohamed Bangura, please come. Honorable members, this sitting is stood down for 20 minutes. Please make sure, go freshen up and come back in 20 minutes.
Check out.
Right, we are still in the House of Parliament, wherein we are following through on the Constitutional Amendment Bill of 2025, which is currently at the committee stage, and for which a third reading will have to be done, and it will be subsequently voted to become a bill. I mean, to be passed to become a bill. I mean, to become an act of Parliament. But however, it's very clear that as it is in the House of Parliament, the main opposition APC, they've walked out of the House of, they've walked out of the well, noting very clear that they will not participate in an engagement wherein about 96 members of Parliament will forge ahead with amending clauses in what they consider the government of the land, and so that's more the reason why they walk out. But just before the Speaker stood down the House for a short break, we saw wherein he called on representatives from the ruling SLPP, the majority leader and the deputy majority leader, and he called on Honorable Mohamed Bangura who is acting at this moment as the minority leader for the main opposition APC, and similarly so he called a representative from the Parliament Chiefs, wherein he held a very short consultative engagement with them as to the fate of the bill that is currently undergoing parliamentary debates and subsequently to be approved. Nyake, it's getting intense in Parliament, more so when this is something many Sierra have predicted that the APC as an opposition will not complete the process of debating on this bill. But this seems extremely crucial at this moment.
This may also not be a surprise for some people. Of course, they have been saying that there must be a specific juncture where the APC would actually work out on this decision, because the position of the All People's Congress has been very sacrosanct. They believe that we should not go with the PR, proportional representation electoral system, and of course in the area of amendment, of course you've heard from Abdul Kabo. He made his position that the amendment doesn't reach the threshold of 2/3 majority in Parliament, which is really very different from what the Speaker is saying. The Speaker says as long as there is simple majority, definitely the amendment must go on. It also makes someone to wonder why you are sometimes member of Parliament. It seems as if the political parties are very strong. They have an influence on members of Parliament, because we have actually seen the position of the APC up to this time, and of course it's very clear on what electoral system they should move with. And according to some people, they believe that the position of the party is what the members of Parliament have actually gone with at the moment, Samuel.
It is very clear from the looks of things that yes, indeed, the political parties seem very powerful as opposed to the constituents who voted in these members of Parliament to represent them in Parliament. Earlier during the debate, during an interview held with the leadership of the APC, they've made very clear that their position in Parliament is their party's position, and as such, that's what they're following through with. So you kept asking yourself question: are they actual representatives of the people, or are they representing the party? It's the same with what's happening from the ruling bench, the SLPP. So according to them, it's their party's decision, this is their party's position, and that's what they're following through with. But as we've heard from the debate here, it is very clear that from clauses 1 to 18 have been adopted by the House. However, clauses 19 to 21, these were, the Attorney General, Minister of Justice, was asked to ensure it is being deleted from the constitutional amendments, but rather it should be forwarded to the into our election laws. It should be forwarded to our election laws rather than it's been in the gunnom of the land. But again, the question that many Sierra are asking at this moment is whether the bill entitled Constitutional Amendment Bill of 2025 will be enacted by this Parliament.
Exactly. It has been a concern as to whether it's going to be enacted. But some analysts also believe that definitely it's going to be enacted for the very fact that the APC has, they have actually worked out. And then, of course, you also heard from the Speaker, he had to rely on several sections, provisions of Act number 6 of the 1991 Constitution. But there is also an issue here of interpretation of what simple majority or 2/3 majority really means, because for the Speaker, he believes that the 2/3 majority are members of Parliament present
in Parliament during session. So I think that's one of the big problems that the Constitution has. And the Speaker, if you hear from him, he was very firm. He was very sacrosanct on his submission. He said that he will take a decision, and that decision will be forwarded to the Supreme Court for interpretation. And so it tells you this constitutional amendment will be completed today. It tells you this law will be passed in a way or the other. But again, as you earlier mentioned, the Speaker relied on several provisions of the Constitution. But the general rule could be found in sections 91 sub 1 of the Constitution, whereas sections 29.3 sub B, section 119 sub 9, and section 137 sub 7 up onto section 108 sub 2B, these are the exceptions to the provisions. But as you rightly mentioned, the Constitution makes very clear that for an enactment of a law which is found in the Constitution, same could be done by a 2/3 majority vote of members present in Parliament. But however, as it is at the moment, about 96 members are present in Parliament, taking into cognizance members from the ruling SLPP that forms about 81 in number. The PCMPs, they are 14 in number, but they have about, I think, one PCMP, one parliamentary member of Parliament is absent. In addition to Honorable Mohamed Bangura and Honorable Thompson, who are the two members of Parliament from the APC who have supported of course they've backed the position of the ruling SLP.
It's also very important, Samuel, of course, in this entire line of argument. You also saw the position of the APC, of course, the member of Parliament, of course, from the APC, Honorable Daniel, had to focus on section 91 and section 108 that actually spoke more on the exceptions to the rule. And then he spoke about the diverse ways in the law of jurisprudence, where sometimes, of course, you may have generality of rules, but there are also exceptions to rules. And the members of Parliament of the APC had really relied on those exceptions. But it seems as if the Speaker, of course, is the head of Parliament. Not even it seems, it's very definite that he has to make his decision as the leader, and he had actually given his rule. It's just going to be another opportunity, of course, for lawyers as well to have several interpretations. Even though, of course, I understand that maybe as time goes on, there's going to be further interpretation of the decision that has been made today. A lot of people are also rekindling this decision to even the decision of Lara Taylor Pierce as well. Of course, we also saw members of Parliament giving a backseat from the APC. It had always been in this kind of situation. So there are also questions about even the level of democracy that we have in the country, where you only have two political parties in Parliament, and then every other time one other political party is moving away from Parliament. But there is also a concern here about the consequences when you have a ruling party in majority most often as well. When it comes to decision making, you will find out that it really moves on the side of the ruling party in governance because they are majority in Parliament, Samuel.
What seemed clear, Nyaka, what seemed clear this afternoon from even during the head count of votes of say those who are in favor of sections 32 sub 3 of the Constitutional Amendment Bill that speaks to the Search and Nomination Committee. It's very clear that the parliamentary members of Parliament are absolutely in favor of ensuring that same becomes a law in Sierra Leone. And they've backed the decision of the ruling government, just as you rightly mentioned. And they are about 13 in number. 13 of them are present. In addition to the number from the ruling bench, it becomes very difficult. As it is 96 members. 96 members does not account for 2/3 majority. When you look at the totality of members of Parliament, that accounts for about 149. So to have a 2/3 majority, you should have yourself 99.3 of the number of members of Parliament. Say 100 members of Parliament should constitute what is 2/3 majority. But however, it looks, the atmosphere is one that many like you earlier said, of akin to that of what transpired during the Laya Telopia's, proceeding or what have you. But again, the question is, has the main opposition APC, have they exhausted every other avenue to have taken such a decision? Because I overheard the minority leader, Honorable Abkabo, when he was making the submission, he said that they've tried as far as possible to ensure they are part of the process. That's more the reason why they participated even in the first voting.
Believe, Samuel, that their own position has been very clear initially. I mean, they made their position very clear, even in the amendment process. They have said that, of course, the entire amendment did not meet the threshold of 2/3 majority. I mean, they did not just walk out of Parliament. They had to make their position, Samuel.
But the argument is not only about the 2/3 majority. The APC believes for every voting within the House of Parliament, the House should follow through on the 2/3 majority.
Exactly.
Whereas the Speaker said, by his own interpretation, because he made it very clear,
and they rely,
that this is his chamber.
And they rely on the same law, the same Act number 6.
The same Act number 6 of 1991. So there comes in the confusion as to the interpretations when it comes to several provisions of the Constitution. So for the Speaker, he did say that this is his chamber, and as such, his rulings becomes final. He said, for the enactment of the entirety of the bill, for it to become law, yes, indeed, the Constitution provides for 2/3 majority. But when it comes to clauses in the bill, and mind you, the Speaker, the learned Speaker, did say that the amendment they're talking about is something that is not in the Constitution. They are not amending a section in the Constitution, but rather they are looking at ways to amend a new provision that should be added in the Constitution. And so for that reason, they should not follow through with the 2/3 majority, but rather a simple majority.
And there was also a debate about whether it's a clause, whether the amendment is a clause or a bill. I had that debate as well, even from members of Parliament. But my concern here, Samuel, exactly. My concern here as well, Samuel, is even on the clause that has to do with the Search and Nomination Committee, Section 32 of the amendment, and it shows that, of course, the President is still going to appoint the members of the Search and Nomination Committee for the appointment of the Electoral Commissioner of Sierra Leone. That is not going to change. And of course, the APC of members of Parliament do not have much opportunity for them to really ensure that is not going to be part of the amendment as well. So it's a huge concern when it comes to subsequent elections in the country, among other things. But then it's also very important that the process has still not ended. This is also what we have to understand, Samuel, because after the voting today, I'm sure that the President has to sign. He has to give his consent. Yes. So it's also part of the process anyway. But it's also not really a surprise to many people to have seen the members of Parliament from the APC moving out. There have been several speculations. I even saw that even from Dr. Sylvia Olayinka Bliden's post, and I mean among other politicians as well. And I think it's in line with what the party wants, not just from individuals. Maybe if it would have been from an individual perspective, one may say that some members of Parliament would have said, okay, well, I want to stand as an individual. I'm not going to walk out. I'm going to stay, among other things. But let's also be very concerned about why is it that the opposition is very keen about even the electoral system, whether we should go with the PR or we go with first past the post, because even in the PR system, some people believe that it's not really just about the system, it's about the kind of model that we are going to adopt. I don't know if government is also very keen about whether or not we are going to change the model, because as it stands, everything in the amendment bill is going through, because the members of Parliament of the APC have left Parliament, Samuel.
Essentially, it's very clear that all the clauses in the Constitutional Amendment Bill, these are clauses that will be easily passed. The fact is, we're only having members from the ruling SLPP and Paramount Chief Members of Parliament, in addition to Honorable Mohamed Bangura and Honorable Thompson, who are from the APC. But there was press release to the effect pointing at them being expelled from their party. But Nyake, you mentioned something very pivotal, and it has to do with, before this time we've had starting submissions from members of parliament from the APC. I think when it comes to the search and nomination committee, the fact is, say for the representative from the media, say that representative, from my understanding, say will be presented by the Silent Association of Journalists. Say Nyake is a representative to serve in this search and nomination committee. So it is the case from the Silent Bar Association and what have you. But I think the contention is this: there is no catch that tells you as to whether or not the president will accept or reject these members. It's very clear, it's very open that the president is not bound by the nominees or nominations that will be made.
I think,
and if the president rejects all three of the nominees, what then comes up afterwards? So that's many questions many are asking. But from the submissions from the ruling bench, they say why twist the president of his powers to appoint a member to serve in such a capacity? So I think we are yet to have a juncture where both minds, the minds are yet to meet.
Exactly.
But as you rightly mentioned, the clause that has to do with same has already been accepted by the House, and they've already voted on that clause, and that clause is what led to the hula baloo that we saw here this afternoon, where in the APC sought the need to ensure they exit the House.
There's also a concern here, even with the composition of the Search and Nomination Committee. There has been a concern as to how are we going to choose these people in the Search and Nomination Committee, because, for example, there is a representative from political parties. How is the president going to appoint those people? Is he going to do it in line with his party, the SLPP, or whoever that will be in governance? So these are all concerns. And even with the civil society, what kind of civil society is going to be part of the composition here is also very important. We even have a representation, a legal representative as well, to be part of the committee. But as far as I'm concerned, I mean, based on what I've seen as a journalist, I think that the composition is important, and I also believe that the only thing is there should be a qualification, very succinct qualification of who is really going to be a member of the committee. But I also love the very fact that it's diverse. It's not just from one set of people. You have all walks of life as representatives of the Search and Nomination Committee. You even have a representative of the media as well. But in the amendment bill, it's not just about the clause that is talking about the appointment of the Electoral Commissioner. There are also other issues. For example, even the threshold for elections, presidential elections, among other things, has also been a concern, Samuel.
Indeed, those are all concerns for, those are all concerns that many Sierra Leoneans seem extremely worried about when it comes to the constitutional amendments bill. But again, we are still here in Parliament, wherein we're following through on the constitutional amendment bill that is currently at the committee stage in Parliament. And afterwards, it will be read for the third time by the learned Attorney General and Minister of Justice, for which the bill will be passed and to become a law. But again, after it is passed, it needs presidential assent, and it will be gazetted and ensure it's popularized for the people of Sierra Leone to understand that yes, indeed, there is a law and there is a new law. So as it is, 18 of the clauses have gone through the House of Parliament, and the Speaker of Parliament has stood down the House for 20 minutes. And afterwards, the session will have to commence. The session will recommence until we see the approval or voting of this bill to become a law within the Republic of Sierra Leone. But nonetheless, yes, the main opposition APC They left the house as a result of some disagreement they had with the guards. The manner to which things seem not to be going, in favor of their party or whatsoever the case might be. So the question many have been asking is, are politicians serving the interest of their party, or are they actually serving the interest of their constituents who voted them in? But nonetheless, Samuel Ibrahim Kurma is my name. We take a short break, and when we come back, we will continue the rest of the conversation.
Here's how to send money overseas using AfriMoney and BNB. Dial *161#. Select option 1. Go to option 6 for overseas